is the Landlord Advocates, where we help landlords become better landlords. I'm your host, Matthew Lyman. Welcome. Well, I'm actually your co-host tonight. We have a very special guest who is joining us to talk to you about all of what's been going on over the last week with New York State. His name is Vitaliy Volpov. Vitaliy is an attorney, and he is also part owner of Serenity Real Estate in Albany, New York. We are going to discuss with you so many aspects of this new eviction moratorium. So without further ado, let me welcome Vitaliy into the studio.
Matthew, thanks so much. Can you hear me?
I can hear you very well. Thank you.
Awesome. Thanks so much for having me here. Thanks for that introduction. I really appreciate it. And I'm glad to be here to discuss this important topic for landlords here today.
Well, I will tell you, landlords, Vitaliy has Succeed REI on YouTube, and he's active on Facebook as I am, as most of you know that. And we have shared videos. We've talked about our videos. We have commented on each other's comments on social media. And I said to Vitaliy, how about you and I doing a collaboration video? And without hesitation, he said, let's do it. And this opportunity came when we said, hey, let's talk about this new eviction moratorium. And Vitaliy said, absolutely, let's do it. Now, what we want to let you know, Linus, is this is information that we are providing to you. Take it as you will. We advise that you probably should hire an attorney to go through this process now because it's very extensive. We have gone over, my team, Vitaliy as well, has gone over all of this nonsense. And I'm just going to change out this because I realized that I have it on the wrong side. And nobody wants to see the label. So we advise that you might want to hire an attorney for this, but we are going to provide you with a lot of information. The law is 71 pages long. It is very, very extensive. It is ridiculous. We are only going to focus on the ERAP program. We're going to focus on non-payment evictions, holdover evictions, and defaults. So please have your comments and your questions related to just that. Anything else we have not focused on. We have a lot of answers for you, but we don't have all the answers for you. That's why it is best to consult with an attorney, but we are here tonight to talk about that. Now, let's move right into the ERAP program. As many of you know, that is the Emergency Rental Assistance Program, where $2.6 billion was afforded to New York State to share that among landlords who have not been paid in a very long time. It's been very dismal, and I'm being polite when I say that this money has not gone out. And we believe that there's a reason for that. I was at a meeting last night with a representative of a tenant advocacy organization, and we actually got along very well. And I asked her, I said, if a tenant applies for this ERAP program and they omit information, they have about 10 days to respond and provide the additional documentation. I said, what happens if they choose not to do this and they get thrown off of it? Their application gets dismissed. Are they able to apply again? Her answer was, yes, they can. And I turned to the landlord group. I sat in the front row, and I turned to them, as we have said on social media, and I believe Vitaliy has done the same thing, is that this is just another built-in eviction moratorium. This could go on for months and months and months for this ERAP. Now, we have said in previous videos, here in New York, you must accept ERAP. If not, that is against the law. It is against the fair housing law called, I'm sorry, not fair housing, but discrimination, human rights law. They call it lawful source of income. Now, I will tell you that I do not believe that that is a lawful source of income. Income is what you get when you provide something to someone else, not something that you just get from the government put in your pocket. But either way, that's what they call that. So you have to accept this program. So landlords, you really should apply, even though you may not want to, because it will only hinder your eviction with the ERAP program. So you really should apply. We know landlords that have got money. Some of our clients have got $10,000 to $15,000 of what's owed. But we have said it's smoke and mirrors. I know Vitaliy has done a couple of videos on the ERAP. Vitaliy, add something here. What do you think? Add anything that you may want to say about the ERAP.
Sure. Yeah. I mean, generally speaking, guys, I think if you have a choice, if your tenant is cooperating with you and you're able to apply, there's really no reason to hold out. Matt is going to get into, we're going to talk maybe a little bit about what happens if you do apply, you receive the funding, and what restrictions the government will place on you if you do receive the funding after the application. But regardless of that, that's not a reason for you to hold out, because the way these laws have been going and the extensions that we've seen after extension, and now with this new response to the United States Supreme Court decision from August 12th, they're clearly intent, and there's clear intention here that they're going to continue trying to extend this. And eventually, if there are arrears from this pandemic time period, they're probably going to be forgiven. And so if you don't apply right now, if you miss this opportunity, there's good opportunity to receive up to 15 months of back rent right now. Now, as Matt alluded to, I am a landlord myself. I'm a real estate investor primarily, an attorney secondarily at this point. My roles kind of flip-flopped over the course of time. I was never an eviction attorney, but I'm certainly very keenly interested in this specific topic in New York State because I am a landlord. I am a real estate investor, just like you guys are. I have a law-trained background, so that I can understand these laws. I can read them. I can find out when these things are happening. One of the first people to find out what's happening and then interpret it and know what to do and how to act within my business. But at the same time, I'm still in the trenches just like you guys are. And I would definitely suggest that if you have the opportunity, if you haven't yet applied for rental assistance, that you definitely do so.
Absolutely. Apply, you may not want to, but you have to. Plug your nose and apply. You will get money. The problem that we find with that is that the idea is that you're going to get all of the money. You may not. You may get just a portion. And whenever you don't get in that covered period, for lack of a time frame, we're going to say January through December. Let's just make up a time frame. Your tenant owes you $12,000, $1,000 a month. The government determines that you will only get $500 a month. So therefore, you're getting half of what is owed. The other half that is owed, bye-bye. You can never ask for it. You can never sue them for it. You cannot evict them for that. If you choose not to apply for ERAP and your tenant is approved, that money will be held up for 6 months in order for them to say, well, you didn't apply. And during that time frame, you cannot evict them for non-payment of rent. You're not going to do a holdover eviction because the money has been afforded to you that you were asking for. And that's why Vitaliy mentioned there are restrictions on that. You cannot evict them. You cannot raise the rent. On a holdover, meaning the expired lease, you can't evict them for that. So what we're stuck in that the government says you must accept this money no matter how much it is. The government could be a real SOB if they wanted to and pay you $100 of what is owed, and you have to forgive the rest. It'd be great if we could do that with a tax. We were watching the other day with the assembly vote on this bill, and Assemblyman Jeff Dinowitz from the Bronx, for the show, I Will Maintain Composure, but his idea was to the other assemblymen who were against this, and women who were against this ERAP, was that, well, the landlord will be able to get a judgment with that money, and they will be able to pay their bills with that money. I mean, that is the most ludicrous, foolish statement. And if he actually believed what he was saying, that is scary. I know in my over 30 years in this industry, we have over $5 million in uncollected rents that our clients will never see. And one of the lies that we tell our clients in our office, and we are right there with them, take toilet paper and that judgment and tell us what has more value. After one trip to the bathroom, you will know the answer. So the judgments are meaningless for most of us. And the tenants know that, and the government knows that. But they believe that we landlords are a little stupid to believe that, oh my God, I'm going to get all of my money, when that's not the case. So in the ERAP program, you have to apply. We don't like it. If you get your money, that's great. If your issue with your tenant is just the money, we understand. Apply. You may not get what is after that. Now, with the ERAP program, if your tenant gets the money and the payment is through the end of, let's say, September 2021, and the tenant fails to make payment on that rent for October or November, you can initiate a non-payment eviction right after. So the money that comes to you is September 30, 31, I can't remember, September 30th, and the money is paid for you. Come October 6th, go right ahead and initiate a new eviction on them. That's the ERAP. If any of you have any questions regarding ERAP, go ahead and post them now. We will try to keep up with whatever questions you may have. Some comments, we'll throw them up on the screen. But Vitaliy and I are going to share what we know. Again, this is 71 pages long, and they reference Section 6, Part AA of Subsection BB of Section 56 of the laws of 2020. It is obnoxious. It is obnoxious. But anything else, Vitaliy, on the ERAP program?
Yeah, so maybe you'll get into this in a minute, but there are a few changes that have been made. They're mostly, as I look at them, mostly cosmetic changes. One of the things that they kind of closed a loophole. Some people are perceiving this as a loophole. If you guys are familiar or not familiar, there's the state program, New York State program, currently administered by OTDA, which is a New York agency. And then there were, I think, a handful of municipalities, I think maybe like 7. City of Rochester, Monroe County, City of Yonkers, Onondaga County, and the towns of Hempstead, Islip, and Oyster Bay. Those were the 7 municipalities that opted out. They all received their own chunk of money from the federal government, and they said, we're going to administer that program on our own, and so we're not going to participate in the state program. So those individuals who were living in those municipalities were required to turn to those municipalities first and foremost in order to get any rental assistance, whether landlords or tenants. And some of these programs, as far as I know, and I've heard from quite a few people, this is months ago now, have already processed them, given out the money. It's all been done in a much more efficient manner than the New York State program has been. And what was kind of circulated out there and argued potentially is that the state ERAP requirements and restrictions that the New York State law imposed did not apply to landlords and tenants who applied through their own municipalities under those municipalities' programs. So that was the argument. So that's kind of a loophole. So maybe the requirements on landlords after accepting rental assistance in those municipalities are not as restrictive, the argument was, as they are under the state guidelines. Well, so this new amendment, what they just passed, gets rid of that. So that's all gone. They're basically saying, regardless of what program you applied under, you're going to be restricted from raising rent on this tenant who received rental assistance for a year after the receipt of the first payment. So the rent has to stay the same. And you also can't evict them for any reason other than non-payment of rent. And then a couple of exceptions that maybe we'll talk about with Matt with regard to tenant intentionally causing significant damage to the property or persistently and unreasonably engaging in various behavior that is a problem. So those are really the only ways that a landlord can evict a tenant after receiving rental assistance funds. And previously there was an argument, at least, that maybe if you're in one of those municipalities, that didn't apply to you as a landlord. That wasn't a restriction on you. They got rid of that.
And with the ERAP program, they are trying to do a little bit better, but even the tenant advocates, they called up and one of the representatives that is a state worker. They have an agency that they paid millions of dollars to run this program, and very abysmal, very terrible. So the state supplemented that workforce with state employees. And we asked on our channel, we actually demanded that not 1 rent cent of taxpayer money going to pay those state workers. It should come out in the contract of the company that was paid to do this. A tenant advocate the other day was on the phone with the ERAP representative, and what they heard on the other side was the person had fallen asleep. They were snoring on the phone. The people at ERAP, they are getting a little cheat sheet You know, like when you call in and complain about something. Well, I'm sorry to hear about your complaint. And you yell, I'm sorry to hear about your complaint. It's a Rolodex of bull that they're telling you. So some of these people at ERAP don't even know what the hell they're talking about. And when they sent the people out, the agencies to administer these programs in these municipalities, they gave them no direction. They gave them nothing. It was intentional. They may claim that it wasn't, but it was. As of July 27th, the numbers have increased, but on July 27th, there was 160,000 applications pending in New York State. Out of the 160,000 applications, only 55 were approved. Only 55. So with ERAP, there is some comments here that I see, and I don't want to lose you in the comments or questions. So we're going to jump into the ERAP questions, and then we're going to go into the non-payment of what you can do when you want to bring a case to court for a non-payment eviction. Let's see. If ERAP pays in December 21 with the 3 future months, I can apply for an eviction in January if the tenant has not paid rent by 1/8. If the tenant is not paying the rent, you can. If the rent is being paid, no, you cannot. And if they're continuing to pay the rent a year after, you can evict for a holdover, but not before then. Let's see here.
I have one here, Matt, that I can take.
Oh, sure.
Yeah. So one, I see the question says.
You want to throw it up on the screen?
Yeah. So what do I do?
If you hover over the question,
yeah,
your mouse, and it will jump up on the screen.
It's not letting me do it. I can just read it off. Maybe I have a restriction on what I can do.
I'm not sure. I made you the same as me.
Yeah. It's not giving me the option. I'm just going to read the question, guys, so that you know it's very short. Basically, it says, what if the landlord does all the paperwork for the ERAP program and the tenant does not submit anything? And when I read the summaries, and Matt, correct me if I'm wrong, when I read the summaries of this new law from various sources, I think New York State Bar Association did a summary, some other folks, journalists did summaries. I thought they said that they were giving landlords an opportunity to apply even when a tenant does not comply. Yep. But I did not see that in the 71 pages that I've read. Did you see it? Okay.
It's not, Vitaliy. There is another bill out there that they have, I think $100 million or $200 million. I will be honest with all of you here, and I think Vitaliy, I speak for him. We have focused so much on this 71-page law and digesting it, and we are educated. Him and I are both educated. My team has over 100 years of experience together, and even then we had to sit down and analyze this. So we did not delve into that. I think Vitaliy and I will probably do something on our YouTube channels or even here later on to talk about the money that you can apply for if your tenant does not apply on their own. Because when a tenant doesn't apply, they're just trying. And what will happen is they will not apply. And then the day that you have them in court to evict them for not paying the rent, they're going to apply. And the court is mandated to give them that information that they can apply. Now, with the program with ERAP, under this new law, the OCA, Office of Court Administration, now has to have in front of the court clerk the ability to look on the computer to see whether or not the tenant applied for this money. Now, apply does not say they got it or they sent in their name and that was all that they did on the application. It will not tell us that, but it will say that they applied. It won't say when they get it. Now, with the ERAP, and I think a lot of our people here and Vitaliy would see, is that with the ERAP program, not one person on our social media that I have seen has received any letter stating your tenant has been denied. A lot of pending, no denial, a lot of pending. And I have said just recently, when it comes to that, they may have been denied, but now the ERAP representatives are looking all around to find out where that is that the person was denied. Because once they're denied, you can move to throw them out for not paying the rent. So by putting the pending aside and putting they really should be putting aside the ones that were denied, because that's totally immoral, unethical, and illegal in my eyes. But to say pending is another word for we're going to deny you, but we're going to pend it out for who knows how long. It's just unjust, very unjust. Let's see if there's any more here. Yeah, we did that one. Yeah, we did that one. Those of you that are on Facebook, if you authenticate yourself through Facebook, it will show us up not as Facebook user, but your name will be there. And we can address you by name and help you. Because as like 518 Travelers, he's very involved. Evan is an attorney in the Bronx, and he is an early follower of the Landlord Advocates, and he's been a friend of ours. And had a judge determined that the new law has a rebuttable presumption that the hardship exists, so I have to prove a negative. Most of my cases are holdover cases where the person is not a tenant. You can't help those New York landlords. We're going to talk about this hardship rebuttal shortly, Evan, and we're going to talk about that in the non-payment aspect of it. Now, the rebuttal of the declaration, you're right, I don't believe, and Vitaliy, jump in here, I don't believe that the declaration of hardship will apply to the intentional and the substantial damage to the property. Now, they may fill out the declaration because we have to give it to them, but I know that they will have the immunity of not being evicted if they are causing all of this damage.
Yeah, my understanding is that that's right, that they can submit a hardship declaration even if they are causing damages and acting in a harmful way to other residents in the building. It becomes, as Evan says, you kind of have to prove the burden of proof is stacked against landlords because they have to disprove certain things and they have to prove certain things that they may or may not have ability to prove, because in order to prove something, you need to have access to information. And when the tenants are holding all of the information and all they're doing is submitting a hardship declaration, now we're going to have a very hard time overcoming that. And this is one comment I want to make about this in the more broader sense with what happened in the Supreme Court on August 12th, when the Supreme Court struck down SEFPA's, I'm abbreviating it that way, but SEFPA was the law. I forget exactly all the acronym permutations that it stands for, but it's the one that was...
It's COVID Emergency Eviction and Foreclosure Prevention Act of 2020.
There you go. Say that 5 times fast.
No way.
So that was the law that basically said a tenant can submit a hardship declaration, and that declaration will serve as a full stop, hard stop on any eviction, any executions of warrants, anything basically. And it had to continue without challenge up until whenever the latest extension of the deadline was due. And so landlords challenged that. Supreme Court said, you were right, landlords, that was a violation of your due process rights. You can't have someone simply say, I'm just going to declare that I have a hardship and no one can challenge it, and therefore, I'm going to infringe on landlords' rights. So Supreme Court struck that down for that reason. So now the legislature went back, and what did they do? And I was looking for this. I wanted to see exactly how they will address this issue, because I knew in the summaries before I read the law itself, they said, okay, well, landlords will get a hearing now. Awesome. I thought, well, let's see what the details are, right? You go look at the details. There are no details. The details are essentially that, yes, you get a hearing, and you have to ask for it, right? So a tenant submits a declaration of hardship. A landlord receives it, and it's up to the landlord to affirmatively, or through an attorney, affirmatively request a hearing challenging that declaration. And the landlord must have a reasonable belief, a good faith belief, that the hardship declaration is invalid. And then they show up to court and they have to prove that it's invalid. And good luck being able to prove that unless you have some kind of an admission from a tenant, right? If a tenant sent a text message to their landlord saying, haha, I have the money, but I'm not paying you. Maybe that will be some good proof. But unless you have their records, have their employment records, have their financial records, which of course you wouldn't. In a summary eviction proceeding, you don't even have the right to collect discovery as you would in a normal lawsuit in the first place, right?
I'm going to talk about that momentarily.
All right. I'm jumping the gun, Matt.
Oh, no, that's right. Vitaliy, we are co-hosts. I'm not the host, we're co-hosts. We're equal here, okay? But we have some great information that Vitaliy was saying, really, wow. We have had, since the passing of this law, we have had about 30 cases in court. Between yesterday and today and the second or the third, I can't remember, we had more cases in court there. And we had some great results. Now, this Facebook user, which I know your name, so I'll just say your user. Oh, wait, that's the tenant. If tenant filed for ERAP up to June 2021, but has not paid anything for July, August, or September, I have not received any ERAP funds. Can I evict? No. And I'm going to tell you why. You said filed for. You did not say got paid for. If you got paid for June up to June 2021, and that's all they're going to pay you, then yes, you can. So if you want to send us back a clarification on that, but as your sentence reads now, no, you cannot evict. No, you cannot. Let's see. This one here, we will be discussing this. Right now, we're going to talk about non-payment of rent and how we proceed with that under this law. And then we're going to talk about holdovers, and then we're going to talk about the defaults with the sheriff. The news is bad. It's bad. But like we said in our thumbnail, we're going to show you ways that you get around this. And one of the ways is that when you file for non-payment of rent now, we all know that we have to include the notice of legal service providers. We have to include the declaration of hardship. And then there was a state form. We call it a state seal, a unified court system. We had to include that. We have not seen anything yet from the chief administrative law judge, Lawrence Marks, whether or not we have to add that. But we are adding it. And there's certain terminology that you have to add. The old one has information on it that you can't challenge. The new one does. Now, we have a great studio here, but we were not able to put an overlay in of what needs to be added. But I am no problem reading that to you or putting it up to the screen. And then when you are watching this in rerun, you can freeze it and realize that now that is what has to be inserted. So when you take it for non-payment of rent, you do the rent reminder, the 14-day notice. With all of that, you have to include the declaration of hardship, the notice of legal service providers, and I still am doing the state seal form that tells them when they can go and get help, that your landlord can't do this and can't do that. You still provide that. The court, one of our local courts said, no, you don't have to worry about that in the middle of August and earlier. In those cases that we were taught you don't have to worry about, we actually taught the clerks who we get along well with that no, that's not how it works. The law is through August 31st at midnight, so therefore any documents that you serve upon your tenants must be accompanied by the requirements under the law through August 31st, 2021. And we were right. We had cases in court yesterday and today, and two different judges, and the judge that heard our cases today opened up the file, and my colleague was there representing quite a few of our landlords. He opened it up, the judge did, and he realized that all of the evictions had the accompanying documents that were necessary. So there was no need to adjourn them out just for that purpose only. So continue to keep giving those notices out. You do not have to give out the CDC form anymore. That was the colored form. It had to be on anything but white paper. That you don't have to do. So do that with your 5-day, do that with your 14-day. You can't serve it yourself. Again, you would hire somebody. Vitaliy is stepping back from that. But you would hire colleagues that he has. You would hire my firm or anyone like us that knows what we are doing. Here's where it gets tricky. And this is almost like a diagram that you would put up on a big wall, because if they don't do this, you can do that. If they do this, you have to do that. So pay attention to what I'm telling you, everyone. Pay attention. If you want to take them to court for non-payment of rent and they hand you the declaration of hardship before what we call pre-petition, meaning that you have not applied, you did not pay the filing fee, you did not get a docket number. If you have not done that, and they gave you the declaration of hardship, you have to provide to the court an affidavit, as we've always done during this CFA, that you do not believe, or that your tenant did not return the declaration of hardship to you, and these are the dates that they were providing it, and as of this date that you signed and notarized it, that you did not get that back. That has to still go with the documents that you give to the court to get your court date. Index number, landlord tenant summary proceeding, housing court, whatever you call it. When you give them that paperwork, there's now additional paperwork that must accompany that. When you serve your tenants, you must give them a document that looks just like this. This document right here has to be on every petition paper that you give. And they actually say it doesn't have to be inside, it must be on top. So when you give the court paperwork, the petition and notice of petition, you must have that notice on top. And if not, you might get a judge that says, case dismissed. You don't want your case dismissed on procedural errors. We had that happen in a local court. It was not one of our cases. It came to us afterward. And the judge said, you did everything right, but you didn't do this. And they dismissed the case without prejudice. Now, one of the things that happens with pre-petition, if your tenant supplies you with a declaration of hardship, this is where we got in Vitaliy. We were in court yesterday and we had a number of tenants show up. And when they claimed that hardship and they gave it over to the court, which the court will be there, the tenant advocates will be there, and they'll be waiving all of them. They're going to be giving them out like they give out candy on Halloween to children. So don't say, oh, they're not going to sign it. Get that idea right out of your head. They are going to do it because it's in their best interest to do it. But here's where we got in Vitaliy, and it was great. Even the advocates and the court were like, wow. We had judicial subpoena ducis tecum ready to go. So when the tenant did either side A or side B of the declaration, side A is the financial side, which is a lot of crap. And side B is I'm over the age of 65, I'm immunocompromised, I'm da. When they submitted that, while they were giving their diatribe in front of the judge, we were filling out the subpoena, and bam! They were served that judicial subpoena ducis tecum. So on the adjourned court date, they need to provide, if it's for financial, W-2s, tax records, pay stubs, anything that they are claiming that they have a financial hardship, they must provide. If it is one where they're claiming immunocompromised, we had one that said yesterday in court that goes against HEPA. No, it does not. You have made a claim in court as a defense to not getting evicted. And I love it, Vitaliy. Thank you for shaking that head. I like that. You made a claim. You cannot make that claim without substantiating that claim. And when you take those tenants to court with that subpoena and they do not provide the information, the court will presume that they are not providing it because it is damning to them. And therefore, the court really has no choice but to rule in favor of the landlord. So you would want to, now, landlords, you don't know about judicial subpoena ducis tecum. That's about records. You don't know about serving that. You don't know about that. No disrespect to those of you that do, but we have to presume that you don't. And it is in your damn best interest to hire professionals. It may cost you, and it will. There's a lot more work that's involved. Fees have to go up. But you have to look at it this way. If you do not challenge this declaration of hardship in court, that notice says right here that the landlord cannot do anything until after January 15th, 2022. So they will adjourn that case out until, and you may not be in court, your tenant will be there until Happy St. Patty's Day. And that's if you're in the area that Vitaliy and I are in upstate New York. If you're in New York City, it's going to be Merry Christmas 2022. If you are looking to bring forth, the 14 days is fine. If you don't want to get a court date, your tenant may say, oops, I'm going to pay the rent or I don't want to get evicted. Before you file for the eviction for non-payment of rent, you have to ask yourself, or we will ask it for you, do you believe in good faith that your tenant is lying, and that you can prove that they're lying, and that you are willing to pay the funds necessary, have the notices served upon the tenant, and take the risk of going to court to be able to prove your case? If you do not believe that this is the case, it is not worth taking the non-payment all the way, because they will adjourn it out, and that'll be in January, February, your case will be heard. But you have to look at the fact, this is September 9th. You're looking at 5 more months of saying, well, I'm not going to fight it. Look at the amount of rent that you can be losing. You can be losing $5,000, $6,000, $7,000, $8,000 in rent, where you don't know what's going to go on. And that ties into the ERAP application too. You are allowed to file all the predicate notices. You can serve them all. Predicate meaning rent reminder 14, 30, 16, 90. You can do all of that. we suggest that you do. And even get a court date, even though your tenancies have applied. Because it may be 4 or 5 months later that you will find out, sorry, we're not giving you anything, and now you initiate the eviction. What will happen is if you apply under ERAP, the court will just adjourn it out until they find out that your tenant has been denied. If they have been denied, then, bam, that next day in court, Your Honor, I want a judgment for what they owe me and an immediate warrant of eviction. Now, when you do this, when we are providing this non-payment summary proceeding landlord-tenant documents to your tenant, we will have to include in there the affidavit that you get the court sworn that you believe in good faith that your tenant is lying. Now, you don't necessarily have to sign it if you hire an attorney to do that for you, because you in the affidavit that is being drawn up, the court did not give that to us, so we have to do that ourselves. Just like with a lot of other stuff, or the default notice and the default hearing, we have to provide that. We have to write it up ourselves. But you have to provide that affidavit, and if you're not represented, or if you are represented, we can do that for you, because you are saying that you believe that this is the case. We are not affirming it. My team is not affirming it. Vitaliy is not affirming it. It is just that we are signing it because you told us what you believe. That has to go in the court papers as well. That is the way that you can proceed with a non-payment. So don't give up hope. The problem is that now they're going to use this ERAP application as the eviction moratorium, because now you can challenge this hardship. Be prepared. There is clauses in that I hate it since day one, and Vitaliy, I know you're going to agree on this one, that I fear catching COVID, and I have no money for out-of-pocket expenses to move. In the video that we did on that, we said a 12-pack of beer, a 24-cut pizza, and you go to a major company, moving company that charges $19.99 to move your stuff, $50 you can move your crap. And one of the things that we said recently with the Kathy Holcomb video that we did about rules for thee but not for me, in that we had said that these people are in the midways, the fairways, the hallways, everywhere that you can possibly be, mingling with other people. And when you ask them what COVID-19 is, like, what's that? But the moment you mention COVID-19 and an eviction, oh no, I'm afraid I'm suffering. No. And then we'll go to an advocate, and the advocate will walk them through the process to delay that eviction. I know it's cumbersome. I know it's overbearing. I know it's hard on us, but we can't give up hope. We can't give up hope. And that's why you come to people like Vitaliy and myself and my team to help you through the process. So that is how we can do non-payment. What I will do here is I have been negligent in looking at comments, but I want to see if there's anybody that has been in court since. I doubt it, Vitaliy, because a lot of them we've held back. We actually have over 70 cases that we held back from applying for a court date because we didn't know what was going to be needed. And the rules, and then the holdover, which we'll discuss momentarily, the holdover ones are worse. Because if you've applied and you got the court date, you may have to apply all over again. But if you held back, we've done, and we've had some landlords who have been lovingly irate with us, and they know I love them. They've been with me for over 3 decades, and I told them, I said, I am not going to move forward with any of these cases, nor any of my team members, because you want us to. I don't care. We're going to interpret these laws. We're going to understand these laws as fully as we need to make sure that we proceed. And landlords, if this costs you a week or two, I don't care. I don't care. I do, but I don't, because I'm not going to jump in and get you a court date. We're not going to be in court. And we're not going to see your case dismissed and have you turn to us and cry, literally cry, Matt, what am I going to do? What you're going to do is you're going to listen to us so that we do the best thing for you. Vitaliy, I'm sorry, next time we do a live show, I'm going to make it so you can pop up comments.
That's okay. Yeah, that's all right. Matt, I just want to...
Hey, Vitaliy.
Okay, I just want to point one thing out for people, and it just piggybacks off what you've been saying. I think this is prime example. The subpoena ducis tecum that you mentioned, doing that in court, that is something that if you are trying self-help as a landlord and you're trying to do an eviction right now by yourself, I mean, you are really just not serving your own interests. And I think something like that, only an attorney who's well-versed, who does evictions, who's on top of these sorts of things, is ready and prepared with something like a subpoena like that. A normal person, an average person who's not an attorney, even an attorney who doesn't necessarily practice in eviction court every day, I certainly don't. You might miss this opportunity because it's so hard to, like I started saying earlier, hard to obtain any information from the tenants. But in Matt's case, is what he was describing, in that situation, the tenant's already in court, and it's the perfect opportunity to serve them with a subpoena so that now they don't have any excuse. They just got served in front of the judge. They have to show up next court date with all the documents supporting their declaration. The other point I just want to make real quick about the declaration, and I noticed this, I don't know if anyone else caught this, but it's so interesting to me that the declaration that the tenant submits doesn't say under penalty of perjury. Did you notice that? It says under penalty of law.
Yeah.
And it doesn't say what law or what penalty. It doesn't say anything about it at all. Yeah. On the flip side, when a landlord has to submit an affidavit saying either that the tenant was damaging the property or acting in a certain improper way, harming other people at the property, that is under a penalty of perjury. See the duality there?
Yes.
I mean, it really struck me. It's a minor point, it's a little thing, but it's pretty damn clear that there are no teeth to this declaration at all. The only thing that we're fighting about, and you fighting on behalf of your clients when you're in court, is really, can I get a judge to agree that there is no hardship? Not that, can I get a judge to penalize this tenant for lying, because they just did. Clearly, since they didn't have a hardship and they submitted this declaration, we just proved they didn't have a hardship. No penalty. There's no penalty at all. And they are giving them out like candy at the door with various advocates. They walk in, they get their signature. Previously, before the Supreme Court decision, it was even easier. Now, guys like Matt are there to at least fight for your rights if you're a landlord in court.
Yeah. Now, when they do, now let's say your tenant doesn't give you the declaration of hardship at all during the entire process and in court. What will happen then is, as a non-payment, I'm doing the declaration, you can still have the subpoena served on the tenants, but at another date. When they adjourn it out, then the process server would have to go out and serve the subpoena on the tenant. It will be done in the courtroom. It will have to be done after. Now, you might say, well, why can't we give them the subpoena no matter what they've done? You can't do that. You can't serve a subpoena on somebody for records when they have not said, well, let's say how I want to say it. You can't ask them for records and documents to fight against them when they have not made any allegations to say that they have something. So the judicial subpoena cannot be issued until after the tenant has signed the declaration. If the tenant signs the declaration and you don't tell the court any of that, you really need to be honest with yourself and honest with the court that, yes, my tenant signed the declaration. Because if you lie about it and they prove that you've done that, Ron Thomas said, you're going to be in hot water. No district attorney in any of the 62 counties in New York State is going to take any of these cases that my tenant lied on that declaration. I want to prosecute. It's not going to happen because there's so many aspects of that declaration. I'm afraid of catching COVID. My out-of-pocket expenses have increased because of work. Well, I was at the gas station today and it was $3.19 a gallon. That's a hell of a lot more than it was last year. Can I claim it? Sure we can. This declaration, any one of us can sign it. Vitaliy and I can sign it.
The problem with that declaration is that, like you said, there's A and B, and then there are subparts under A, all the different financial potential hardships, right? And we don't know which one they're picking. They're just saying it's one of them. It says one or more. All you have to do is attest to having one or more of these criteria. And how do you challenge something that you don't know exactly what they're claiming? All you know is that they have either reduced costs, they have a loss of income, they have, this hardship, they have that hardship. It could be any number of things, and a lot of them are very subjective.
Yeah. So most judicial subpoena dues take them as most of them are usually a half a sheet of paper. That's it. Ours at my office, my team's office, I should say, is 3 pages long. We have that thing, and we'll cross out what doesn't apply, and we'll initially, we are firing them off. But if they do it after court, then we have it more formalized. It's typed out, it's all of that. But we can't have it typed out when we're sitting in court. So we handwrite it all and we hand it over to the tenant. So, hey, you got to provide. It's if you're willing to try that. Now, Lizzie is an ardent follower of ours too. Her question is basically, my tenant is working under the books. They're applying for ERAP. I know that it's fraud. If I report them, I'm afraid to get any money. I want to tell you to do the right thing and report them, but you know that if you do, then not the landlord, but the tenant will be in hot water if they're proven, and the person that's hiring them will be in hot water as well if they apply for ERAP when they're working under the table. But will you get any of the money when that happens? I doubt it. But there's another program that you might be able to apply for later on that we'll do a video on, but this is more important for us right now. So you may not get the money now, but you might get it later. And there's a lot of tenants that are doing this. They're working under the table. They're not going to claim anything. And that's why some of them don't want to fill out the application. So if your tenant doesn't want to fill it out when you force it upon them, then the other program that is out there, which we have to study, you will be able to apply for that because your tenant is being uncooperative, and you may be able to get your money that way. But one of the things I tell everybody who gets judgments over my 30 years and thousands of evictions, do not count on ever seeing that money. More so now than ever. I know it's terrible. You may get a judgment. We had a judgment end of August against a tenant for $32,000 in court. She admitted that. She asked if she could have another month to stay. I said, no. We'll give you another week, but you owe $32,000 in rent. And you want another, well, no. But we have to be careful with that because they go in front of a judge and they can scream and cry and holler. And now because of this new law, that warrant of eviction may be vacated, or we have to go back to court and have a settlement or a status conference. We're going to talk about that shortly. We're going to get into the holdovers momentarily, but Vincent says, what health records should we ask for? You just ask for all. If they want to scream HIPAA and all of this other stuff, you do not have to say, well, I want to know. And then come to court and they say, well, I sometimes sneeze. Show us the medical reports that claim that because of that, you can't be evicted. If you have AIDS, if you have stage 4 cancer or whatever, absolutely. Submit the paperwork. We understand. Not that we totally agree with it because people may use that and they've been using it for months not paying rent. But health records, you don't have to be specific with what you're asking for. The subpoena just says, if you're going to come to court and claim that you have an immunocompromised disease or a situation that does not allow you to be evicted, be prepared to bring in the health records that corroborate your claim. And if you don't, you're out of here. So you don't have to be specific on what health records that you're asking for. Let me see if there's any more here. Received a judgment in February of $23,000 in possession of 4 years, no rent. Yeah. We lead the chorus, the choir. We don't, we're not in the choir with you, we're leading it with you. And we've seen that repeatedly. New cars, jewelry, vacations to Disney World. Billions of dollars is owed in rent to landlords across America, and these tenants are having a damn good time. I have said this on social media. I don't know I've ever said it on YouTube. I'm not sure. I know I've never said it on a live show, but I'm going to do it now. And no one yet has challenged me, and I dare anyone to do so. I am saying that COVID-19 has been the best friend that tenants have ever had. And it has. Prove me wrong. I don't know if anybody here wants to because they can't. Violation, subrenting, collecting. Oh yeah, we've had that. We're going to talk about that in the holdover section, Rick. Do you want to have anything more, Vitaliy, about the non-payment or the subpoenas? Go ahead.
So one question that keeps popping up from a lot of different folks is they have a property, a tenant hasn't been paying, they want to try to get rid of them, and it's a small multifamily property where they either want to move back into the property themselves or have a relative move into that property. And people are trying to get at, is that an exception that they can use? I don't have a good handle on that question. Do you, by any chance, Matt?
I apologize. I was reading comments, Vitaliy. Can you just
Yeah.
refresh me?
So
I'm sorry.
folks are saying basically that I have a property, a tenant hasn't paid me rent, and I want to either have a relative, close relative, move into that property and use that as a basis of for an eviction and get rid of a tenant, or myself, I want to move back into my property and I want to be in that apartment. Do you have a handle on that as a potential exception?
I do. When you want to evict a tenant, it has to be a 4-unit or less, and an immediate family or yourself has to move into that apartment that you're telling the person that you want to get them out. Now, the question is, what's an immediate family member? In my eyes, it would be mother, father, brother, sister, grandparents. I don't know if it will extend to aunts and uncles and cousins 10 times removed. So the farther out that family cluster gets, the weaker your argument will be. And this is legal. If you want to do that, move your 18-year-old kid in there. Get him out of the house for a couple of months. That you can legally do. I'm moving my son in. He's 18. He needs an apartment. He may not need it. You might have, my house is a huge house. I got plenty of bedrooms. But you just want to be able to get that tenant out. You move your son in for a couple of months. Son, come on back home. I love you. Then you re-rent that apartment out to someone else. You're not breaking the law when you're doing that. The law does not say the duration of time that the person has to live there, but under HUD regulations and FEMA and all of, not FEMA, but under Fannie Mae, Freddie Mac, my team has addressed that, and we have decided that 2 months of an immediate family member living in the home will satisfy that need to get that tenant out of the apartment. Go for it. Make it happen. Make it happen. Let's see. And then we're going to get into the hold. And the holdovers, I will tell you, cumbersome. There's different levels of that. Anyway, I'm not familiar. Evan's from New York City, and Vitaliy and I are from upstate.
Yep.
And the rules in New York City are a monster, a Tyrannosaurus Rex, Godzilla, King Kong, all wrapped in one. And the thing that we are saying up here in upstate and outside of New York City, the rules in New York City are running up on us like the Roadrunner, and they have no idea because the problems in New York City are not the same problems that we have upstate. Right. But now they are, because the New York representatives of the state legislature believe that they are, and now they are becoming that way. So, Evan, I'm not familiar with that, but you know your stuff. If you're in the Bronx and you need an attorney, Evan is the person you need to talk to. Evan's the one to talk to. But let's just see if there's anything more. The comments are coming in great. We'll move in and move forward with the holdover. Yeah. You don't want to go through the ERAP. Not wanting to, you don't have an option, Jack. You don't have an option to say, I don't want to go through ERAP. And Jack may have joined in late because the crowd is getting bigger on our show. You cannot say no to ERAP. But you can say, I'm moving my family member in. And that might say to the ERAP representatives and the local people, there's no sense doing this because you'll boot that guy out. What I would do, looking at how long the ERAP program may be, I would think, and how much they may owe you. Your tenant may owe you $10,000. One of our clients got $15,000 about a week ago. Get the money and then start the eviction on them. If you want to do that. Yet you have to take it personally to yourself, Jack, and weigh the consequences or the decision, not consequences, but your decision. Do I collect the money after ERAP and then throw their butt out so that my parents can move in? Or do I just get them out now and get my parents in there?
And just so people understand, what Matt is talking about is not collecting money for some future months and then immediately turning around and evicting a tenant. What we're talking about is back rent collected, and you probably won't even get all your back rent. There's so many cases where a tenant stopped paying in April or 2020, or possibly even before that, and they've been not paying for 2 years, let's say. ERAP is only going to pay you for 12 months of back rent and possibly 3 months forward from the date you applied. So I have some applications pending right now that I submitted for some of our tenants in July, and now we're in September, right? So that I asked for 3 months. They asked for 3 months going forward, but we still haven't gotten paid. So if we get paid by October, it would technically be 12 months of back rent plus 3 months of forward rent from the time we applied, but it's really 15 months of back rent, because by the time we get the money, we're already in October and they've owed us this money this whole time. So the point Matt is making is just that if you have that option of potentially moving in a family member after the fact, and the lease is month to month or has expired, there's no term lease that you would be violating with that tenant. If it's not legally prohibited and you have the good reason to do it, such as a family member moving in, then that's totally up to you, and you can make that decision on your own.
Yes. On the ERAP application, we have not done it because we wanted it, but as I understand, you fill out the first page and then it moves into the second page. I couldn't get it printed out for me with, from the 10 advocates, so I do work on it, I'll be honest with you. But I'm told that there's a little box that you have to check to ask for the 3 months going forward. Go ahead, Vitaliy.
So guys, I have a full, almost an hour-long video on my YouTube channel where I walk through every single step of the process of applying for ERAP online. You guys can check that out. The channel is succeedrei.com if you don't know me. But go on there. It's a video I posted probably 4 or 5 videos back, maybe a month or 2 ago, but it's called How to Apply for Rental Assistance ERAP, and you'll see the thumbnail. I go through the entire thing step by step, and I talk about cooperation with the tenant, what I would do if I was trying to apply and work with the tenant. I've actually applied with tenants on the phone and with tenants there in person with me. I would go to that. I took a laptop with me, went to a tenant's house, sat down, hashed it out. Basically, I had to work for the relationship to make sure that it's not irreparably broken, but this tenant was able to, give me the information that I needed, and he was cooperating, and we submitted that application. I'm hoping that we'll actually be able to get funding. And that was the full 15 months because he owed that much. But definitely check out that video if you want to, get some information on how to submit, how to answer questions, how that whole process works.
And you'll see down at the bottom, there's a ticker that we have. One of the Landlord Advocates, Vitaliy, Succeed REI Real Estate Investment. Subscribe to our channels. We have so many videos on there. I think Vitaliy is up to like 75 or 76, so we're up to like 68 or 69. So we have a lot of great videos on there, and our videos complement each other because what I may leave out, Vitaliy will catch, and we're doing great. His videos are great. I watch his. So subscribe to our channels, watch our videos. Ladies, we don't make money. I yet have not been monetized. Vitaliy maybe, and he might get enough every month to maybe buy a Happy Meal. So it's not, we don't make money on this. Our studio equipment, and I tried getting it to work, but I had multiple cameras around, but it wasn't working for me tonight. And I like to focus my energy on reading this and studying it more than setting it up. But we have lights around us, we have cameras, we have sound equipment, computer systems. I've spent thousands, I'm sure Vitaliy has.
Yep.
And the editing time that we spend on this, we do it because we care about you and we want to educate you. Now, 518 says, I thought courts were closed. Courts have been open for months. Some of the small town courts, they're not because they're afraid to open up. They don't know what to do. But we've had dozens and dozens and dozens of cases since February in court. They're open. It's a matter of where do we go and how far can we get in court? What will be the resolution in court? That's the problem. So yes, but you want to bring your 18-year-old son in the apartment, or my 2 apartment? Yes, you can do that. You have to go through the process of a holdover eviction by getting them out. But we're going to talk about that. I keep saying that, but we're talking and we're trying to pull up some questions. Let's see. Somebody that we may not have already talked to yet. Penalty under perjury? No, Facebook user. I wish we knew your name, but I'm calling you a Facebook user. They're not going to apply that. They're not going to apply. The tenants are not worried about any of that stuff because there's provisions in there that all of us can fall under to claim that we're all suffering hardship. So they're going to do that. Like Vitaliy said earlier, we could make claims sworn to and before on this day under penalties of perjury. We believe this. We have to hold ourselves, and the government holds us to a standard that they're not making the tenants do, which is not fair. It's not right. Let's see. What course do we landlords have to report on tenants that refuse to apply? There's nobody to tell they're not applying. You go forward with the eviction court date with ERAP or non-payment. You go forward, and then at that time they will say, I'm not applying, screw that program, I'm not doing it. Your Honor, you just heard him say, I'm not applying, therefore I want a judgment, immediate warrant of eviction. I doubt that the tenant will do that, because under this law now, the court must inform the tenant of the declaration and the ERAP. They must, under law, tell that to them. As if the tenant advocates are not doing that already enough, now the court has to do it. And we have to do it too, with paperwork that we have to provide all of the tenants with every document that was shown. So then they may apply just to shut you up and to keep the case going for another 4 or 5 months. Let's see. And then from here, we're going to go on with the holdover aspect of this new law. I have a tenant who was just served a notice to terminate. We also included hardship form. This tenant was originally living with someone else. And I challenged the form that they fill it out. Notice to terminate was, I assume, the 30, 60, 90 day that you want them to move out. They include, and yes, we include the hardship form, but it depends on what it is that you want to challenge. With a holdover, and this is a good segue to get into the holdover aspect. We believe, and Vitaliy, see if you interpret it the right way too. This is a question that stumped me. Can we proceed with a normal holdover eviction for no cause or reason? In Albany, you can't. You have good cause. And they're trying to do that in New York State. I don't know if you did one, Vitaliy, but on the Landlord Advocates, we have the good, the bad, and the ugly. Good cause eviction. We're not going to get into that now. Watch our channel. If Vitaliy has one like on his, watch his. But I don't know. And Vitaliy, my team thinks that we can proceed with a normal holdover eviction of termination of lease or termination of tenancy in court without having to substantiate any lease violations or damages. Vitaliy, what do you think?
I did not think that we could. I guess let me correct that. If a tenant you're saying if a tenant does not submit a hardship declaration?
When they're submitting a hardship declaration, that we can challenge.
Yep.
The question was, can they challenge that? But we don't know what it is that you're challenging.
Right.
Is it because the tenant was originally there was someone else, and now there's only one person there? I don't know what it is, please, that you're going to challenge. But that's the thing that's up in the air. Can we move forward with a holdover eviction if we're not claiming nuisance, safety hazard, or substantial and intentional damages? That's up in the air. Go ahead, Vitaliy.
So I think, there's two things, right? So there's, the way I look at it is two questions I would ask first before answering that question. Number one is, did the tenant apply for ERAP? If they did, obviously that halts any evictions regardless of what kind they are, even including holdover as I read it. Two is, once you serve them with the holdover for whatever reason, let's say the lease expired and you want them out with no reason, and they serve a hardship declaration, and the whole point of, and as you can read in the prelude to the law, what the legislature is talking about is to prevent homelessness, prevent congregate housing situations, which is the same rationale that CDC was giving for its eviction moratoria. But the point of that they're trying to get across, the legislators, they don't want people to be evicted out on the street. So to me, as I read the spirit of the law, and maybe it's a little bit reading between the lines, but I personally think that if the tenant fails to submit a hardship declaration and they did not apply for ERAP, and even after they show up to court and there are advocates there giving them the paper, putting right in their face for a hardship declaration, they're still not submitting it, I think you can proceed with the holdover eviction. But chances are they will submit a hardship declaration, and then you're back into that realm of challenging the hardship declaration if you have a good faith basis to do so. But I don't know if there's just a straight path to holdover and to a judgment right now.
Yeah.
But
I'm leaning in that direction too, Vitaliy. It seems too easy.
Yeah.
And when the people who wrote these laws, they don't want it easy for us at all. Even learned individuals like Vitaliy, myself, and my team, this is like, I was up 3 o'clock this morning just thinking of this crap. And it's hard on us. When you read some of this stuff, Section 6 of Part A, B, B, subsection, it's like, whoa, wait a minute. So I'm leaning in that direction too. And yet ask yourself this question too, landlords. if you're not evicting them for non-payment of rent and destruction of property being noisy, why bother now? If it's something, and we've seen some landlords out there say, well, I just don't like my tenant. I don't care. You don't have to like your tenant. I don't care whether you like them or not. You're not having dinner with them. They're not marrying your daughter. Who cares whether you like them or not? So I'm leaning in the direction that you may want to try it. If you're willing to go to court and pay the fees or whatever, and you want to be the, what do they call it, the canary in the coal mine to see if it is dismissed, we'll be more than happy to help you with that. And any other firms such as I would be happy to help you with that, but we make no guarantees that the court will allow this case to go through. Because those are easy evictions. I just want them gone. We should be able to do that. Good cause eviction in Albany County, Albany City, and what may be proposed in New York State will no longer allow that to happen. And that's something that we need to fight. They're looking at that. But with that, I'm agreeing here with Vitaliy that I do not believe that you can. And even if you can, why take the risk? Because right now, we've seen some landlords too, Vitaliy, who are like, well, I want to raise the rent. But you want to raise the rent if somebody's been paying the rent right along during the pandemic? Don't be stupid.
Right.
Don't be stupid. Don't do that. And we did a video on that, Vitaliy, a few months ago. Late fees, late rent. We've seen landlords who have actually pushed tenants out by late fees and young. You're always late. Who cares? Right now, with the holdover evictions, I think what we have to really look at, and this law pushes it down the throats. They repeatedly intentional and significant damages to the property, not allowing for the quiet enjoyment of the other tenants or creating a safety hazard. Now, if you have already filed an eviction on a holdover, and now you want to go to court and claim all of these problems that they've caused, and you did not allege that in your 30-day notice, not 60 or 90, because when it comes to a nuisance or anything like that, it's a 30-day notice. It still is. If you did not allege any of that in the 30-day or in your petition, your case is going to be dismissed, and you have to file all over again. Now, go ahead, Vitaliy, please. Jump right in.
Sure. I just saw Evan's comment, which is very interesting. He's referring to the RPAPL 713, basically referencing when a situation where the individual you're trying to get rid of is not a tenant, an actual tenant, but I had a situation like this recently with one of my firm's clients where they asked me to assist with an eviction. We ultimately didn't end up needing to evict because the person moved out voluntarily, but they were essentially, this was a unique situation, but it was a licensee holdover eviction is what colloquially it's referred to. And, Evan's point is in New York City, obviously, things are a little bit more complicated, but I just wanted to highlight that there are situations where it is not a traditional landlord-tenant scenario. In my case, it was a son of a father who himself was there as an institutional resident of our client. So our client was renting from the owner, from the apartment complex. They had a father who was a recipient of services of our client organization. And then his son just moved in and refused to leave. And we were scrambling. They're trying to figure out how do we get this son out? Because, he's affecting their services that they're providing to the father and all these different things. Father didn't want him there. And so I had to go through this process, which is a little bit shorter. It's more abbreviated and it's outside of the parameters, as far as I can tell, of, the holdovers that we're talking about, because they're not applying to those individuals who may be outside. But those are, rare situations. Most of our audience listening right now have a landlord-tenant relationship with their tenants, and they are covered by these provisions. But I just wanted to highlight what Evan said.
Yeah. One of the things, too, when you mentioned that, we have heard on our social media, I heard it last night at a landlord meeting, is that they're squatters. No, they're not squatters at all. They are your tenants.
Yep.
When you're not and under the Housing Stability and Tenant Protection Act, they can move other people in. Whether you're not or not, they are your tenant. Yep. So don't use the word squatter. They're trespassing. As much as it makes you feel good to say that, it's not the facts. Now, when you take the tenant to court for a holdover for damages and whatnot, you need substantial proof. In a civil court, a civil procedure is called beyond the preponderance of the evidence, and you better have a lot. The court will not go on your mere suggestion that they are causing a nuisance. If neighbors are there complaining, they will have to come to court and testify. You can't have a sworn statement from that because it cannot be cross-examined. So they're going to have to be there to testify. We had a landlord the other day who sent me photos of another tenant parking their motorcycle in another tenant's parking space. No, that's not going to cut it. It has to be drastic. It has to be excessive. And the thing that kills me is that there's no clear definition of what substantial damage is. One judge might say, you broke the bathroom door, you're out of here. Another one, you blew the roof off the house. Okay, now you're out of here. So what is substantial damage? So we have to be very careful. So when you come to us, and I would say Vitaliy as well, you come to any of us, we're going to look at what you have. And do not get mad at us if we tell you we do not believe you have enough to go on. If you want to push the issue, I'm sure that we will be more than happy to help you. Unfortunately, it's going to cost you money. But we're going to let you know up front, you may not have a case. So if your case is dismissed in court with prejudice or without, don't look at us and say, well, we told you so. We've done it longer than you have. Listen to what we're telling you. Now, if you have already filed for that, or not filed right now, if you have not filed for it, but you haven't contained in the 30-day notice, you will also take their transgressions that they have caused, and that will be inside of your petition papers. The court is requiring that you also provide an affidavit affirming or attesting to what you already had on the 30-day notice of nuisance of noncompliance and on your petition papers. It's already there. Now, some might say, oh, that's enough. No. Don't go on that premise that's enough. Some judges might say it is, but you must assume that every judge will say, no, it's not. So you would have a separate affidavit affirming what you already said on the 30-day and on the court papers themselves. Just add it to it. It doesn't hurt. It's another sheet of paper or 2 or 3. You add it to it. If you don't, you can find your case dismissed by virtue of not even having that affidavit. You can challenge that. On the holdover, that's the thing that we have to be careful of. The definition of substantial and intentional. Now, when we get into the discussion of defaults with the sheriff, that's when you landlords better take, maybe a value or something, because when we get into that, you're going to blow your snap. It's really, really bad. So in the holdovers, it's very complicated. So we do have some notes here. Vitaliy, I'll go over some of my notes, and while I'm doing that, if you want to add some things to the holdover end that I may have missed,
okay.
Go ahead, Vitaliy.
So what I was going to talk about, what I wanted to kind of touch base on, and I don't know if this is the right time to jump into it or not, because this actually applies, it actually still piggybacks to the hardship declaration, and it would apply whether it's a holdover or a non-payment proceeding. But if you noticed, I don't know if you looked at this, I think you've highlighted this page. I'm looking at the page 52 in the 71-page law. And that talks about the expiration date. And that talks about which sections of the moratorium, the new moratorium that they have implemented, are expiring on January 15, 2022, and which ones are, or which one, I should say, is still in effect. And that is the rebuttable presumption reference. And this is why I'm saying, and I think Matt is saying too, if you have any reason, any basis to challenge a hardship declaration, you must do so in the timely manner. You must do so at the time that it's submitted, at the time you have the opportunity. Because if you don't, the way it's written is, if you don't challenge it, it creates what's called a rebuttable presumption, which just means that the judge will presume that there is a hardship unless you present some convincing evidence otherwise later on. So what a scenario that we're talking about, and this is how it ties into everything, is that you go to file against the tenant now in September of 2021. They submit a hardship declaration. You say, okay, well, maybe I can prove that they don't have a hardship, but maybe I don't want to bother with it. I don't want to spend on the attorney costs, whatever the case may be. On January 15th, the hardship declaration will expire and I'll be fine, right? Well, the problem with that is that they also amended the Tenant Safe Harbor Act. And the Tenant Safe Harbor Act describes what COVID-19 covered period is. And in one of my recent videos, I talked about how the previous description of what the termination date of that covered period that allows a judge to consider whether a tenant has a hardship defense against an eviction was previously very vague. So now they've identified that as more specifically as January 15th. So now we have a definite finite period during which they will say that this is the time period, covered period, during which a tenant could claim a hardship. Well, it just so happens that it lines up with January 15th. And if you were to wait until January 15th, and then you were seeking to evict them based on non-payment between September and January 15th, in my scenario, in this example, you will be faced with the prospect of still the Tenant Safe Harbor Act being in effect and the tenant being able to use the hardship presumption, because you didn't challenge it originally, against your eviction even after January 15th. This is how I'm interpreting this law. Matt, you tell me if I'm wrong on this, if your team has looked at it and they think that that's not how you read it. But that is my concern, because when you look at page 52 of this law, in section 11 talks about this act shall take effect immediately, and they list all these different sections except for the section that talks about the presumption, all expire on January 15, 2022, meaning that the presumption of hardship continues past over and above January 15th and will likely be used or potentially be used by a tenant as a defense to any future eviction attempts on behalf of the landlord. That to me is insane. That's the craziest part of this law, and they snuck it right in there.
I will be honest with you, they just didn't get in because I didn't get to that part yet. I was like, oh my God, because this law also talks about tax liens, commercial evictions, mortgage defenses. We did not want to get into that. But that's the point. I know when I look at this tomorrow, I'm going to read that through.
You're going to find new things. Yeah, absolutely.
And that's what we said earlier to you, landlords, is that we have a lot of answers, but not all the answers, because it's so in-depth. And I even said to some of my people when they come in, when they say, well, I want here, read this and tell me what you think. And they get the 1 or 2 lines and say, I don't know what that means. I said, well, what do you think it does to us when we have 71 pages of what you just read a paragraph and don't understand? One of the things that I'm glad I looked at my notes, and these are my notes, people that we have put together. I use 3 different color highlighters on these. If the court has awarded you, and I'm going to make sure that we get this right because it's so important, is that if in court, and I'm in 2 sets of glasses, one to read and one to see you, and right now my reading glasses I'm not going to look at. If they already had an eviction already in court and they ruled in your favor, they are going to bring that case back to court.
Yeah.
All of them. And when the holdover ones, when they bring it back to court, it's terrible. And what makes me so angry and so disgusted with these people that pass this rotten piece of crap is that if you want to, you've evicted a tenant because they've destroyed your place, they're noisy, they're terrible, they're rotten, they're louder than a train going by your house. A tornado, Hurricane Ida has nothing on what your tenants have done to your house. So the court rules in your favor. They will bring that case back to court, and I will tell you what they're going to do. They're going to ask, the court shall hold it, if court has awarded a judgment against the respondent prior to the effective date of this section on the basis of objectionable or nuisance behavior, the court shall hold a hearing to determine whether or not the tenant is continuing to intentionally cause significant damage to the property or persist in unreasonable behavior that substantially infringes on the use and enjoyment of other tenants or occupants or causes a substantial safety hazard to others. Now, when you look at this, these cases are what we call adjudicated. That means the court has already ruled in our favor. They have already made a determination that there is, in fact, enough evidence to award you the judgment, and in this case, the warrants of eviction. You may get money for what they owe you after holding over. We'll talk about that some other day. But they granted you that, and now they're bringing the tenants back to court to see whether or not they are still being bad boys and girls. That's unbelievable. Your Honor, they broke up my place. They broke up the windows. And we've had people here on the sidebar who have said the damage that they have caused. And now I have to come back to court, even though I defended myself. I have to come back to court and say, Your Honor, or here's worse. The tenant says, Your Honor, I was just mad at my boyfriend. I was mad at my woman. I was mad at my girl. I broke up the windows. I had that happen when I first became a landlord. They got into a fight with each other. They knocked over the refrigerator and broke every single window in the apartment. They were ordered by the district attorney's office to make amends to me. The amount of money that I have, I don't know if you can see my hands. Do you see any money in my hands? I have yet to be paid. I'll never see that money. So why is it that talk about adding insult to injury, that now we have to sit with these people in the courtroom and have them say, now what happens? How do we prove that they haven't done any more damages? So is the court going to go, Vitaliy, on the premise that the tenant now has a little apron on, little Bo Peep, or the little bow tie for the boy, and say, I've been a good boy. I've been a good girl, Your Honor. I haven't done anything bad anymore. I promise. Cross my heart, hope to die. I know I'm being theatrical when I say that, my friends, but for those of you who have followed me on and off social media, you know I'm that way. Because, Vitaliy, this is crazy that you have to substantiate your claim when you've already done it already. It's almost like a double jeopardy almost.
Yeah. I actually was thinking about that. Is there potential double jeopardy claim? I mean, I guess double jeopardy applies to criminal proceedings, but maybe there's a similar res judicata. I think that's the claim essentially, that that maybe would be a challenge to that section of the law. But yeah, I think it's insane, and but the real reason is, once you know what the real reason behind the law here is, and I kind of always step back and look at the big picture with these things. I'm not as close to being on the ground, obviously, with the eviction proceedings and the details as you are. But looking at the big picture, as a landlord, as someone who owns over 70 rental properties myself with a business partner, and also being an attorney, and watching kind of the state and the state of our government bodies, the governor's office and the both houses of our state legislature, the intent has always been there. It started when I started paying attention to these things, was July 2019. It's when I first started posting on YouTube. But the thing that I started noticing is that's when they started tweaking the law to make it more favorable to tenants. And they've been slowly chipping away every single step. You know, you got local laws that allow landlords, or they allow tenants to stay in their rental properties, barring there being good cause to evict them, that you can't raise rent more than 5% per year. All these rules and requirements and restrictions are coming here from New York City, where the whole purpose of it was that there's a shortage of housing, shortage of affordable housing, all these things. But it's been creeping up upstate and central New York and western New York. And the reason for that is because fundamentally there's a certain group of our legislators who do not believe that landlording is a legitimate way to grow wealth, make a profit, run a business, and there's something evil and improper and wrong and unethical about being a landlord. Even the word landlord, they hate that word. I don't particularly care for the word. It doesn't matter what you call it, but it's a real estate investor. And I'm going on a little bit of a diatribe and kind of a side tangent, but this is what I truly believe. And if you guys follow me on YouTube and watch any of my videos, I've talked about coming to this country as a first generation immigrant. I was 12 years old when I came here. Family had nothing. My parents had nothing. Their degrees didn't transfer. We didn't have any money. Started from the bottom, had no advantages, no connections, nothing here whatsoever. And all it took, because of the great country that we live in, and this country is a great country, is hard work, taking the opportunities they were given, learning about what opportunities exist, and then making something of those opportunities. And one of the best ways to do that, and I've been championing this entire time, is through real estate. And our state legislators do not believe in that concept. In fact, they prefer for people to be dependent on the government, which is, as you know, someone coming from the former Soviet Union, I'm not a fan of that, okay, of any form of that type of governance. But that's what they want. The whole purpose of this is to use, and certainly the pandemic has been a hardship on a lot of people. It has hurt a lot of people, either from their health perspective and also from the government responses to, protect people from the pandemic and the virus. But they've also used this opportunity to restrict property rights and real estate ownership and landlord rights to as far as they could possibly restrict them. They know that there are certain limits. Supreme Court smacks them back when they go too far, but they've pushed it pretty far out from where it was just 2 or 3 years ago.
One of the things that, and I know Vitaliy will catch on to this, I've told people that a lot of what's happening here in New York State happened in November of 2018. And some of November, what happened then, the election of 2018 changed the makeup of the New York State Senate.
Yep.
And a lot of what the Assembly wanted and the governor's office wanted was stopped at the doors of the New York State Senate. So the New York State Senate swapped control. A lot of what they wanted was like, oh my God, they were dancing in the streets. They were celebrating, party that was $29.99. They were having a grand time. And since then, a lot of stuff, by the time I may even do, and we are going to do more videos, we're going to talk about some of those laws that they've had. We were going to do a video on the House of Stability and Tenant Protection Act, one video, and I'm like, no, that's a mini-series. That's a mini-series. But there's other rules that they have had, and there's more that they're putting out there that a lot of you are not aware of, that Vitaliy and I are. The good cause eviction, they're looking at 3% rent increase. Anything more than that, they call it an excessive rent increase. Excessive? Now, you're going to laugh. All of you are going to laugh. I don't drink coffee. I'm a 53-year-old man that drinks chocolate milk in the morning. The price of my chocolate milk went up since I've been buying it, like 30 cents a half a gallon. It went up from, I think it was $1. No, it went up to $2.79 to $3.19 a half a gallon. Okay. That's more than 3%. I can't go into the store and say, you went up more than 3%. No, you need to lower that down under the 3% threshold. But we landlords are subjected to so many regulations and rules, because that's what Vitaliy said, is their form of oppressing us even more. And that's the word I have used so much since COVID-19 that I've ever used in my whole life. And that's what they're doing to us. And that's why when we look at these hearings that we have to have for a holdover eviction, and I want to go through more in case I miss anything, it was not pages 9, 10, and 11, Vitaliy, are the ones that I focused on from that mentioned the hearings that they had to have, the fences that they may be able to use. Now, the other part that we had was defaults and warrants. Now, the defaults and warrants, that is where you have a tenant that did not come to court on the first appearance. The court requires you to have a default hearing. Those notices have to be served upon the tenants. The court did not provide those documents, so you have to go to a professional and have them done for you. And obviously we do that. They have to be served the declaration then. They have to be served that other cover page that we mentioned to you earlier. They have to be served this again on top of everything. So once they get that, you go to court on the default. Great. Your biggest thing, I will tell you, the greatest defense that you have right now is we don't want tenants coming to court. We don't want them to. In any case whatsoever, we don't want them coming to court. Because they will come to court. We got one Vitaliy. This tenant is a nightmare. She's a rotten woman, just very nasty. She did not go to any of the court appearances. She did not go to the default hearing. She knows that the sheriff is on his way, and it is a he, on his way. And now she wants to apply for ERAP. She wants to apply for the declaration. And they're waiting until the very end to do that. So when we give them the notice of default, if the tenant does not appear in court at that time, the court should be granting you the relief that you're seeking in the petitions that you have filed, or that professionals like we have filed on your behalf. If the tenant shows up at the default hearing at that time, then they may sign the declaration then, and you can challenge it. So that it can be made all the way through. Now, when the sheriff's department or the constable or the marshals in New York City come to throw your tenants out, that is the warrants of eviction. That is the thing that we all have been dreaming for and wishing for so much over the last 20 months. What will be 23 when this is hopefully all over. We'll get to that moment too. The warrant will be served upon your tenant. The tenant can actually give the sheriff the hardship declaration at that point. Now, the warrant paperwork, and I should have brought one here with me, has to have COVID-19 verbiage on it. If they don't, the sheriff will not execute. Our local court gave us a whole bunch of warrants the other day, and I said to my colleagues, send them back, we can't use them. They did not have their verbiage on them, which they should have. Now, from what we understand here, and it's applied in New York City, the chair of the City Marshal Department in all of New York City, any warrant that has been issued prior to September 2nd, signed by the judge prior to September 2nd, is vacated. They make them come back to court and their status conference, even in a non-payment. So all of those that have not been executed, and when we say executed, means the sheriff is throwing them out and you change the locks on the door. That's executed. And that has not been done, and we know how long that process can take. Here in upstate, we're telling our people 21 to 28 days normally. Now it may take longer. In New York City, oh, who knows? Either way, they're going to have now an opportunity to defend themselves once again. Now, it did say in one of these sections, Vitaliy, and I did not like this. It said here that in a post-warrant of eviction, that means after court, that at the status conference, in any eviction proceeding, if the respondent provides a hardship declaration to the petitioner, the court or an agent of the petitioner, blah, 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 the execution of the warrant shall be stayed until at least January 15, 2022. That's on page 48, Vitaliy, lines 1, 2, 3, and 4. I kept reading that over, and I'm saying to myself, well, if that is true, what we read here, that could make this law unconstitutional. Because it's removing the due process ability that you have to say that your tenant is not suffering. Even though they took it to the 11th hour and 59 seconds before, bam, you're out, they still are allowed to do that. That section right there, and correct me, Vitaliy, and let's see it, we're on the same page, says that you cannot proceed and the eviction is on hold with the sheriff's office until after January 15th, which just happens to be a Saturday, Sunday, the 17th Martin Luther King Jr. Day. So they did that just the right way. That when they stay warrants until Friday, the tenant just bought themselves 2 more days. Legal aid and the courts know what they're doing when they do that. But either way, reading that, if that's what they hold up to, we may have an opportunity here to challenge that. What we are suggesting that we do, I don't care what it says right here. I mean, I do, but I don't. What I would suggest that you do, if that hardship is presented to you, and if it is presented to you after, you must write the docket number on the declaration, or the LT number, to the court and submit that to the court. The sheriff is mandated by law to provide that declaration of hardship if the tenant signs it. Now, we don't know, and this is another one, if the eviction was predicated on the nuisance and the damages, and the sheriff is already there to throw them out, will it be mandated to go back to court? Because as we said, if you've already had the hearing and the court issued the warrant, then it gets back to court. But if the warrant has already been issued to the sheriff, and the sheriff is on his way there or on her way there to throw the tenant out, are they going to make us have a status conference to see whether or not there's still being damage on the property, being a real choke? That's the question that we have. And if they are, Vitaliy, we're telling our people we're going to challenge it no matter what. And then when the court says, no, we're not going to hear this case, then the lawsuits will happen. What do you think, Vitaliy? What do you think?
This is a tough one for me. I mean, obviously, kind of a procedural twister, right? With it's almost like a dog chasing its tail, right? That's kind of what I'm picturing with this. But I'm not so what exactly, what's the argument, the unconstitutionality argument with this particular requirement? Can you flesh that out for me a little bit more?
Process. Because here, they're saying here that post warrants of eviction, any eviction proceeding in which an eviction warrant has been issued prior to the effective date of this act, but has not yet been executed as of the effective date of this act, including evictions prior to March 7, 2020. Why they're still going on that is ridiculous.
Right.
But that's another argument. The court shall stay the execution of the warrant at least until the court has held a status conference with the parties. In any eviction proceeding, if the respondent provides a hardship declaration to the petitioner, the court, or an agent of the petitioner, or the court, prior to the execution of the warrant, the execution shall be stayed until at least January 15, 2022. If such hardship declaration is provided to the petitioner or agent, such petitioner or agent shall promptly file it with the court, advising the court in writing with the index number of that case. When I read that, when they have that section there, they might very well have something 89 lines later that may contradict what they said there, which is where they're trying to confuse everybody, including people that Vitaliy and I who know what we're doing. But when you read that, I'm looking at the due process because they're submitting that declaration again, and they're saying that it's on hold until January 15th. The warrant is on hold. Now you are presenting the same thing that the previous declaration did, that the self-attestation remains and you cannot challenge it. What say you?
So I think the thing for me that would make it problematic from a procedural standpoint and potentially a due process standpoint is if a tenant had already originally submitted a hardship declaration, perhaps they weren't successful with it, and the landlord proceeded to eviction, and now they're using this section of the law to submit another hardship declaration at the time right before they're served with the sheriff and getting kicked out of the apartment. That could definitely be a problem as I look at it, because then you didn't get, if you're the landlord, you didn't get your due process on the first time around because there's no effect to it. Like there's no enforcement of it. If the tenant can still do it and submit another declaration to stay the execution of a warrant again, even after losing on the original hardship hearing, then to me that would be a problematic interpretation. Now, I don't know if that is what they are trying to do, because maybe they're also just looking at, because there's another set of cases where there was no hardship declaration conversation done, right? Perhaps the warrant was issued prior to these laws that talk about hardship were passed, and that warrant is, landlords attempted to execute that warrant, and maybe that's what they're getting at. So they want the tenant to be able to have an opportunity to stay the execution of that warrant, and then the judge would have a status conference and they would figure out what to do then. Maybe that's the other scenario, and I don't know which scenario is going to be more common.
So you're thinking that they've already had the case, it's already been adjudicated, and the argument of the declaration has been defeated.
Yes.
Then once it gets to the sheriff, they cannot make that same argument over again.
I don't think they should be able to. That would be a real, end run around of the rule here, of the whole point of their response to the Supreme Court's August 12th decision. The whole point of it was to give a meaningful opportunity to challenge and review a tenant's declaration. And if you win that challenge as a landlord, you should not be thwarted again when you proceed to the natural conclusion of your proceeding, right? Which is the execution of the warrant. And if that's not the case, if the legislature is allowing this sort of double dip, then I do think that it's a constitutional problem for them. Absolutely.
But they did that earlier with the holdover, that they're bringing the tenant back to see whether or not they're still being a bad
Right.
boy or girl. So they've
Right.
already done it here. So now they're just kicking the can forward, which a lot of people have said they're kicking the can forward, that they may be doing that again, only at the warrant stage. Hopefully that they're not. And a lot of us friends out there, you may ask, why don't you guys know this? Because it has not been presented in court yet. We don't know what the judges will say. This is all new. One of the 10 advocates at the landlord meeting yesterday, she was spot on with everything. We're actually good friends, and really good friends. And she has said these laws are changing ever so fast, and ever so, in many ways, they're very hard to understand and interpret, that we don't know how they will play out until we're in court to play the game. So far, everything has been very well with us, but it looks like warrants going forward. If we go to court now, and we've already had cases over the last couple of days, we had around 23, 24, something like that in the last 2. Those warrants that they go through, the sheriff's department should execute those warrants without the need for them submitting another declaration. My fear is, Vitaliy, when they mentioned prior to September 2nd, and that is what the Marshal's Service in New York City has said. Anything prior to September 2nd, they have to have a status conference to see what's going on. And anything after that, I think we're safe. But that's the question that we have to ask ourselves, and we're going to delve into that. Not here, because we need that answer too, friends. We need to find out, are they going to have a status conference and have them have a holdover or submit the declaration of hardship, rather, after the sheriff was already come ready to throw them out? Are they going to make us do that? Now, this one, we have a holdover case from September of 19. Wow. On last day, it was August 31st. Judge said he did not know what the new legislation allowed him to do. He should not be a judge if he doesn't know that. Lawyer said no new court date, but yet we were not yet granted the warrant to evict. Of course not. This is happening in some of the small town courts that we work with. And I tell you, you know what we're talking about with some of the small town courts. We had one that we went to the other day, and I won't name the court, but they have 3 different offices in that building. My garage is twice the size of where this is. We've had some courts where they actually have folding chairs and paneling on the wall. So those small town courts sometimes have a lot of trepidation on how to move forward. So what do? They don't move forward at all. And the law does not say that they cannot move forward. They just don't know how to, so they don't move forward at all. That is just as bad as this legislation that was passed. So in that case right here, the judge doesn't know. I will tell you, with all due respect to who that person may be, that person is not a judge. I would say they're probably a justice, a town justice, where you do not need to be an attorney. Whether that's right or wrong, some of them are great. I've worked with town justices who are spot on. And I worked with some that have called my office up after the passing of the House of Stability, who were on the bench and called a recess and called me up and asked me the interpretation of this law. And I'm like, wait a minute here. Why are you asked? And I'm okay to provide that. And we were honest too. I will tell you, we were honest. Whether the information was favorable to the tenant, we spoke the truth. We're not going to do that. And some landlords out there have asked, and I'm sure Vitaliy has been in that position as well, have asked us to circumvent and look the other way. We're not going to do that because, one, we have reputations. We have a lifeline here. And we're not going to do that to hurt you. And we've turned people away who have asked us to push the envelope and do this and that. And we will tell you, we have not been in business for over 30 years by doing that. We're here to help you. We're here to do the best that we can for you. And if you don't like the advice that we give to you, go someplace else and get the advice that you're looking for. We would never tell you one of the things, Vitaliy, that we tell all of our people. I would never tell you what you want to hear because I don't care. I'm going to tell you what you need to hear, because when you walk out of our offices, you're going to know the truth. And that truth should help you feel better knowing what goes forward. We're not going to fill your head with all kinds of jargon and all sorts of bull crap and make you think, hey, I won this one, when you don't. We have seen, and I think we may, I don't know if Vitaliy, there's anything more you want to add on the warrant side of it?
No, I think we've pretty much covered it at this point. Like you said, I think it remains to be seen what judges will do with the law, what will come in the future months as this thing unravels. But I have a question for you before we move on to maybe if you're planning to wrap up. But I have a question for you.
We can go on as long as you want. I will tell you, I'm going over 3 hours. I'm not saying you have to stay with me.
Okay.
I'm going over 3 hours. So.
Here's a question that I think a lot of people might be wondering. What do you give as chances that January 15th is the true last end date for New York State eviction moratoriums?
I love that question. We have said on certain videos that we believe that it's not going to happen. It's not going to continue. And I will tell you, when I'm wrong, I'm wrong. And I was wrong to say I don't think it's going to continue because I just felt that the basis of it was removed. There's no mask mandates. There really isn't anymore. People that are out in the public. The video I did with Kathy Hochul, not with her, but about her, was about the hypocrisy of going to SPAC, going to legislative SPAC. Yeah. It's great to have Vitaliy here too because he knows the area. I can mention SPAC, and some of you may, what the hell is that? Yeah. It's an amphitheater where a lot of people go. I've gone. I graduated from there. High school, that is, many years ago. But people are all out and about. I have said now, I think that they extended it by 5 months, so that it gives them 5 months to come up with some asinine, ridiculous, stupid reason to extend this once again. Will it be, oh, it's cold outside and we don't want to make the children all cold and we don't want to put people out in the winter time? Well, you're doing it to us. When landlords are coming to my office talking about killing themselves, crying tears, which makes me cry. I'm crying. I have literally cried over these laws, Vitaliy. Not out in public, but I'm crying at my office, in my suite. I'm crying at home over these. When I hear tenants tell me, or landlords rather, tell me their stories, and they're upset, and they're coming to my office, and I hug them and I hold them. I don't want to get to that point, because I'm almost there now. It makes me upset. Vitaliy mentioned earlier his background of growing up in Belarus and coming here and emigrating. I did not. But we have a video that I did way back ago of where I came from. I came from a background that is nowhere conducive to the life that I lead now. Drug alcohol family. I was homeless when I was 17. I had $40 in my name and a box of dirty clothes. That's how I started out this world. Welfare put me up in a cockroach-infested boarding home, so infested that when I threw the covers off of me, there were roaches in bed with me. It was summer of 1986. I was 17 years of age. Yes, I'm 53 years old. And I slept outside on a hammock, one of those, those outdoor hammocks. So I didn't want to sleep in that house anymore. I worked my butt off. I have rental properties as well. I have a great business. I have a 3,500 square foot home with 18-foot ceilings. I have a beautiful home. I'm not bragging when I say that, people, because I go to the bathroom the same way you do. I put my pants on the same way you do. I have a great life because we worked our asses off, Vitaliy and I have, to be where we are today. A phrase that I have used many times on social media is that people have to learn to overcome to become. And a lot of people out in this one, and this is another phrase that I use, and feel free, Vitaliy, to use it yourself and anybody listening, is that for a lot of these tenants and advocates and other people in this world to complain all the time about us, because it's us, those people, they got money, whatever, it is much easier to complain and condemn the success of others than it is to create your own. And I'm not going to feel guilty about what I drive and what vehicles I have and the business, because one of the things, and this is not for you people watching, this is for the people that will complain to us and to you about what we have and what we do and all of that. This is now 8 o'clock at night, and I love being here. I look forward to this. I've done live shows before. I think this is Vitaliy's first live show, and it will not be his last, I guarantee you that. I'll drag him onto the show. I look forward to this so much, especially being with Vitaliy, because Vitaliy's YouTube channel, Succeed REI, is much bigger than Landlord Advocates. He's got almost 25,000 subscribers. I don't know how many hundreds of thousands of views that you've had on yours. We are small potatoes. And a lot of times in the YouTube world, collaborators only want to collaborate with those people who are equal to them. educationally and all of that, Vitaliy and I are damn close. But he has far exceeded me on YouTube. And when he said, Matt, I'd be happy to do that with you, I was moved. I was physically moved by him saying that, because it says something about who the man is that's co-hosting the show with me tonight. That he is saying, you know what, Matt, I want to work with you. And we have done private conversations on this, talking about how we're going to work together. And I have bragged to members of my team that Vitaliy, I'm calling him a member of my team, social media, but he's so damn close to where I live that we are going to lunch and dinner very soon, and we're going to physically be able to meet. But we have overcome. And for the legislators to think that this is so easy for us, that we can get this money back and we can recover and do what we have to do to get to where we are, no. We've had landlords who have said to us, Matt, I can't pay my taxes. Matt, I can't fix up the property. What do I do? And I tell them what the government tells you to do. Borrow the money. Where? I don't care where. Do what the government tells you. Borrow it. I don't care. Well, I do. But on behalf of the government, speaking for the government, I don't care where you borrow it. Just borrow it. Why don't they make the tenants borrow that money to pay us? Why do we have to borrow money to fix up our properties to the degree that we had it before they moved in? And I can tell you, my tenants, Vitaliy, in one of my houses that I was in court for, they did not communicate with me since September of 2020. August 31st, the evening of the 31st, it sends me a long diatribe about the condition of the house. There was one thing that I had paid thousands of dollars to get fixed, a leak I had paid, I approved, but he complained about the horrendous living conditions. I lived in that house. I put in $85,000 in a 1,400 square foot home, jacuzzi tub, tile inlays, $7,000 worth of appliances, refrigerator, stove, dishwasher, and microwave, $7,000. I put a lot of money into that. And for him to tell me the horrendous condition, we're in court later on this month, and I can't wait to confront this kid and maybe his girlfriend there to tell me how horrendous it is. Because how foolish it is for them to go up against me, who has handled thousands and thousands of eviction cases over 30 years. To think that you're going to step up in court and compete with me? Now, I know that sounds cocky, but you know what, though? This is the landlord advocate who's here for you. Vitaliy is here for you. So if what I'm saying maybe will seem as cocky or arrogant, that's for you, my friends. When you hire my team or you have us help you, holy SH, you are in for one hell of a fight, because I don't call these properties yours, I call them mine. When these tenants are destroying the property, they're destroying my property. When they owe the rent money to you, they owe it to me. There are so many people out there who you can hire, and all they see with you is a dollar sign. We do not. If I did, I would not cry over these laws. I would not be doing what Vitaliy and I are doing with you tonight. We would not be doing this. We would just not educate you, and that you flounder, then hire us. And the time spent with you tonight and Vitaliy, we could be doing casework that we have sitting around that to help in-person clients. And we do it. But we are here because we care about you and we want to help you. Vitaliy, go ahead.
Yeah, and so I just have one point to make. I think this will be kind of my last kind of wrap up for me, and then I'll sign off. But I think you're absolutely right. I think that I want to be level and kind of balanced with everything. So I don't want this to be an us versus them mentality, landlords, tenants mentality. And, obviously people, legislators in government have that mentality, and they kind of feel that way, that the people who are landlording, who are investing in real estate potentially don't deserve it. They're kind of, using people, they're using tenants to become wealthy and all that stuff. So that's one perspective. The other perspective is, of course, a lot of landlords get jaded and they feel like tenants are pawns, and I don't want to, personalize them at all because of these past bad experiences that we had. So I want to try to keep it balanced. I get it that with the pandemic and the government response, a lot of the middle to low income individuals, who are also happening to be the group that rents more than owns homes, were impacted in that they lost jobs. They couldn't continue making their payments for rent as well as other bills. And that I sympathize and understand. And, so I don't want to minimize that. There may be tenants that end up watching this video if you put it up on replay, but I'm not trying to minimize that. What I want is I just want some balance, and I want some understanding. And guys like us, like you said, we know what we're doing. We've got pretty good incomes. We've been doing this for a long time. We can withstand a lot of these waves and a lot of these storms that come at us imposed by our government. The problem is those folks who are in the comments who are talking about tenant owing them $70,000, or another person was saying they're owed $23,000. That could be an unbelievable amount of money that they can't overcome very easily, if at all. And there are a lot of bad apples, not all of them, and probably a tiny fraction of bad apples who are tenants who are taking advantage of the situation, just as I'm sure there are some bad apples who are landlords that are taking advantage of the situation. But the way these laws are stacked, it's a lot easier to take advantage of the situation if you're a tenant than if you're a landlord. And what these guys in legislature and the governor's office fail to realize is that these are not nameless, faceless corporations that own these properties. 50% of landlords in this country are mom and pop landlords at the very least. And so these are the people that have 1 or 2 or 3 properties maybe, and they worked all their lives, and maybe they're elderly or in retirement age. Maybe that was their retirement. And what they're doing is they're taking away those people's livelihoods and leaving them with no recourse for 23 months now going on, except for to spend thousands and thousands of dollars with potentially uncertain outcome on attorney's fees and help from guys like you, which is great, of course, that guys like you are out there doing this. But the problem is that some of these people, some of these landlords are unable to afford that. They cannot make ends meet. And it just feels like they keep getting hammered over and over the head by our legislature and by our governor's office. So that is what bothers me about the situation. And that is why I do what I do. And this is one aspect of what I do in terms of my social media presence and what I talk about, which is supporting those people who are looking to better themselves through personal finance, through real estate investing in particular. I want to be there for them. And this is one aspect that right now, over the last year and a half, has been pulling people back and holding people back. So I want people to overcome that and then focus on building that wealth and building that real estate portfolio and those other things that are not adversarial litigation context and laws and, how else are we going to get screwed today by our government? But the other side of it, which is the happier side, the fun side, which is investing in real estate, growing your wealth, getting to a point where you don't have to rely on a job and so forth. So that's where I want to get back to. But the problem is that we've been kind of stuck in this rut for a year and a half plus now, that it's very hard to do that at the same time as you're battling these battles. So that's pretty much what I would say on that.
I want to respond to what you said. And
sure.
He hit it on the head in that I'm angry with this stuff, but really it's the legislature and the governor's office and other entities across the United States that have allowed the bad tenants to do what they're doing. And therefore, they're giving all the tenants a bad name. You're going to see landlords who are warehousing apartments. And for those of you that don't know what that means, landlords are holding on to apartments and they're not renting them out because it's so hard to get rid of them, the bad tenants. And I will tell you, in the years I've done this, we work with so many tenants. We actually, Vitaliy, have had landlords who would go pro se. And they will see me in court and they will say, I want to work with that man. And they don't know that my office is the one that's facilitating the eviction of them. We've also had cases where tenants have cried. They had their case, and my colleague may be up at the table. I might be sitting down in the front row where we sit in the court, and they will come out and they will give me a hug. I've had tenants that our office have evicted who have later went on to become landlords themselves and have hired our office to help them. I will tell you, with Vitaliy's background and mine, we know what it's like to do without. My clothes came from Salvation Army, the Sally House, and even through college, I was getting my clothes there. And I would grab the suits, and I would pray to God that they would fit, because I didn't have the money to get them hemmed up. That's how I hope they fit. And that's where my life was. So I can appreciate both sides of the fence. But when I have my dear friend Donna, who works with a local organization that helps tenants and works with landlords, she was at the meeting yesterday. She's been at my home for Christmas parties. I gave Donna a hug yesterday. I haven't seen her in a while due to COVID. I work with other programs here in our area. I won't say what they are because that's, for them. Vitaliy would probably know them if I mentioned to him off air. But we work with these organizations. They would call us up and they would ask us for help. They complimented our team yesterday and how we approached and worked with them in court. And they would call us up, hey, Matt, what do you think? If we were such bastards in this process with tenants and tenant advocacy groups, they would not talk to us. Legal Aid has worked with us many times in court. They have even come to our defense when the court realizes that, something's missing in the file, and no, it's not. We will work with Legal Aid. We are friends with Legal Aid. Not all of them. I will tell you, not all the Legal Aid attorneys are. Because some of them are brand new and they're trying to make a name for themselves. And they were doing it at the detriment of working with. Because sometimes we're going to win, and sometimes Legal Aid is going to win. And some of the newbies, the new attorneys need to realize there needs to be some level of cooperation between the two. We may not all going to walk away with a giant smile on our face, but as long as we walk away with a, okay, I lost, I won, he lost, I won. So you're right. We don't want it to be an adversarial relationship with tenants. We absolutely do not. But some of them make it that way. They are enjoying the fact that they can't be evicted. They're enjoying the fact that they're not paying the rent. They're having a great time. For those tenants, and there will be tenants that will watch this. For those tenants that are doing that, I don't care what happens to you. I don't care if you're living on the lake, living on the side of the. I do not care. And put it on the record. But if you're somebody that's trying, and the courts know all of the area of Vitaliy, all of them, from Albany to Waterville and every letter in between, know that if you are trying, Ideal Legal Support Services and my team will roll the red carpet out to help you. We've done it many times, and we'll continue to do it. Now, I will tell you, there was a comment up here that I want to share. Harleen Andrus. I'm going to call her out. She's probably getting all red-faced right now. Harleen, when I mentioned my team is Mark Judah. My team is Joe Volato. They represent all of our landlords in court with us. There was myself. There is Kim Scannell. She's a real estate agent, and she focuses on a lot on title search. And there's Harleen Andrus. Harleen Andrus owns Homes by Harleen, and her specialty is leasing and tenant placement. She is a wonderful dear friend of mine. I love her to death. She took me out for my birthday. A bunch of us went out to a nice dinner and had a great dinner. Texas de Brazil at Crossgates Mall. We went, Vitaliy. We had a great dinner. Wonderful time with her. She is a dear friend, and she has helped me. There was a time in my business where there was some really bad stuff going on. I won't go into it here. There's litigation pending on that. But she jumped right on board with me from day one. She's been a friend of mine. And Harleen, you know I love you. I know that she was at the meeting yesterday. I love Harleen, and I have to call her out on that. And she'll probably send me a text message momentarily saying, "Oh, Matt, you embarrassed me." Well, I don't care because I love you, woman. She's a great lady. But Vitaliy, you're free to go. Your bail has been, given back. You can leave. You can stay. I will tell you, if you are landlords, I want you to know Vitaliy Succeed REI. Subscribe to his channel on YouTube. Hit the like button on his videos. The notification bell. I am very flattered that you wanted to do a collaboration with me, and I hope this is not the last one that we do. We're going to do more. This is his first live show, everyone, but I'm going to tell you it's not. Because if he thinks it is, I'm going to contact him and tell him that he's going to do more. He's very educated. He's very, very poignant with what he says. He's right on par, because if he wasn't, he wouldn't be here with me. And we've had people, Vitaliy, out in the real world, in our world, not the social media world, who have asked me about my team. Well, Matt, what do you think? And I have said they would not be on my team or our team if I did not feel that they would do a good job. I have a damn good reputation over 30 years in this community. I have over 1,300 clients. And if I felt Vitaliy was not of a high caliber of knowing what he knows and caring the way he does, he would not be on this show with me tonight as my co-host or even a guest. He would just be somebody that I would wave off like a fly. That is not Vitaliy. I am flattered that you were here with me, Vitaliy. I appreciate it. I'm very thankful, and you have to come back. Or if you do a video and you want me to come on as your guest, and you can control what videos come up or what comments, I'd be more than happy. Just let me know.
Sounds good, Matt. Thanks so much for having me on. Thanks everybody for joining in and listening and leaving your comments. I appreciate it, and hope to talk to you soon.
Absolutely. Thank you, Vitaliy.
Take care.
You too. Bye-bye. Now, Landlords, I am still going to be here if you want me to. I see that we have a nice audience here. I'm here to answer any questions. And I did not want to go through some of the comments that we see here because I didn't want to get distracted by Vitaliy speaking to us because we were interacting. So we can go back to it and we can see any comments that we were here that we may have missed. Thank you. No, thank you for watching. Thank you for asking questions. Because if it wasn't for you, I wouldn't be doing this. So, no, thank you. On mixed property, residential owes 42, restaurant owes 120. My property is 33,000. Taxes are due in July, and I don't have it. I got a penalty and interest rate. Why is that being allowed? I agree. Why? Because we have to pay all of our taxes, and if not, we get hit with that 12% or whatever the hell it is. We're hit with that. But why? Now, I will tell you, part of this law was commercial evictions. That would be something that I will do maybe with Vitaliy or just myself. It probably won't be a live show. It might be a video on our YouTube channel that we will discuss how to do a commercial eviction. We have a couple now that we're doing at Ideal Legal, but not a lot. And I don't want to say that they're not important to me because the one client that's doing them is a great guy. He's hanging on us for the help, and we're providing him that room to pull them up. But the residential ones, there's so many now that we wanted to address that. But we will address the commercial evictions. They can go forward too. There's declarations of hardship that they can file, so that can still happen. But we will be working on that as well as the program or the bill, the law that's out there that will help you collect rent when the tenant does not cooperate. With a lot of thank you. You're the same way. We love you. Can we review page 51 section about questioning the declaration before January 15, 2022? And we have to wait for a content when we get it once the moratorium is over. The page 51, there is 71 pages. We printed it out at one time, and it was like 34. And it was fine print, single space. My eyes were just like going everywhere. I couldn't do it. So we printed it out. We will address that. We will look at that. But like I said, we wanted to address holdover, default, warrants of eviction, and non-payment and ERAP. We wanted to address that. And we can go back. If you have questions as we go on, we'll be happy to address those as well. But like I said, we didn't go over too much of the comments because I didn't want to get distracted with Vitaliy speaking with us. Let's see. Can we rewatch this afterward? Yes, you can. Yes, you can on YouTube, and it should also be playing on Facebook as well, at New York Landlords and Landlords Only, and on our YouTube channel. You absolutely can. That's why when we put up information such as this has to go on every top page of the court papers that you give. It has to go on top. We know that you can't write that all down right now. There's no way. But you can stop it and replay and write it down. Your attorney should be handling this. I know a lot of you may not want to afford it, and I know they can be expensive, especially in New York City. But to have something like this that's not included when it's supposed to be, to get your case dismissed on a procedural error, is not something that you want to have done. You have to look at how much they're going to owe you and the possibility of throwing them out. Is it worth taking the risk of taking them to court? And for a lot of you, yes, it is. Let's see. Yes. Anyway, nobody wants to evict good tenants. Nobody wants to evict at all. And some of the premises out there and the mindsets that we love to evict, no, we don't. It becomes necessary, and when the legislation that's out there and is slamming us left and right to the point where we can't even breathe anymore, we get slammed on the mat, they're making it harder. They believe that they're making legislation to help the tenants, when in fact they're doing just the opposite. If they make it easier for us to evict bad tenants, it leaves opportunities for good tenants to move in. But if you make it so hard to evict, it will happen. They will be evicted. Just how long will it take is what we have to look at. Or how long do we want to wait to put a good tenant in, because they may claim they're a good tenant. But when restrictions are put on us to review the background of the tenants, and we have to really review. We did a video, what we call a points to ponder videos, less than 1 minute long. And on that video, we had said to landlords, do not rent to money, rent to people. Because the money that is being paid to you by the tenant today to move into your place belonged to the landlord yesterday that they did not pay. So don't just rush into renting to a tenant because they got money. That's the dumbest thing to do. You rent to people and not rent to money. But you're right. They absolutely are screwing us over. They don't care about us. And it is the good tenants that are going to be hurt. The good tenants that are trying to make payments, paying as much as they can, communicating with you. Those are the ones that we are willing to work with. It's the ones that haven't. My tenant did not communicate with me from September of last year to August 31st of this year, when there was court proceedings going on. How long would it have been before they communicated with me? 3, 4, 5, 8 months later? Who knows? We had to take the initiative to evict them in order for them to communicate with us. Too late. Too late. Let's see. And finally, we can understand that. And I probably don't know who you are because you said you're going to come into the office to see me. So I apologize by not knowing what your actual name is. I may know, and don't hit me if you say me, I apologize. But Angela Sandabab, I will tell you that a lot of us are inundated with phone calls. Now, I'm not Angela Sandabab. I know him because my office represents his father, and there was the pictures that they have. Angelo is a supporter of landlords. He does support us. He voted against these moratoriums. He's not for them. So I will speak in his defense in that regard. As far as the phone calls and emails, I will tell you that our office is inundated with many phone calls, many landlords coming in, asking questions, emails, text messages, instant messaging, phone calls at 2 or 3 o'clock in the morning that we have to return when we come into the office. Not that we don't want to, but the more phone calls that we do and the more phone calls that Angelo does, is less work that he can do to help us fight the good fight. And the same thing with us. We told, our staff has told landlords who have called and asked questions, watch the Landlord Advocates, subscribe to the channel, watch the live shows, and a lot of what you have questions for will be answered. So I don't know Angelo's office, but, try them again. I can't speak to why they're not returning the phone calls. But it may be, and I speak for you also, my friend, but a lot of times we are hearing the same story over and over again. Not that we don't care, because we absolutely do. But to hear the same repeated story, we will tell you, we know your situation, we know it very well, but the time spent talking to you about your situation is less time spent actually fixing your problem. And that's what we have to do. And when we talk about fixing problems, the one thing that we have shared many times on our social media is that landlords have to become more proactive. We have to participate. We have to send out emails. We send out about 150 to 200 when we send them out to legislators and landlords. And we share here on social media. A lot of times we have seen landlords when we have presented issues that they are facing, that landlord A is facing. Landlord B is not facing that situation right now. And they're not really paying attention. And the thing that we have said many times before is landlords, we have to address landlords A's problem today because it could be our problem tomorrow. We have to work together. It may not be a problem that you're facing today, but it will be eventually. And if we solve the problem today, or at least put forth knowledge to the legislators that we are sick and tired of this and we're not going to take it anymore, they may think twice before they pass legislation. Now, I know that's talking out of my you-know-what, because in the legislation that we have now, we can cry and scream and hue and cry as they used to do back in the old days when they were looking for a criminal. We can do all of that, and for some of them, they just don't care. They don't listen. Senator Jeffrey Dinowitz of the Bronx, or Assemblyman Jeffrey Dinowitz of the Bronx, when this vote was being taken on this law, has said that the landlords will be able to get a judgment and collect on it and pay their bills. If he believes that, he's a fool. I say that respectfully. He's an assembly member, but he's still a human being like the rest of us. And to believe that is not the case. Great points. My tenants outlets shares the property when I actually do. We have said so many times that the tenants, you're the caretaker. They own it, you're the caretaker. We wish that they would treat it like they own it and pay the rent and take care of the property. But only to the point when they want you to do something for them, that they act like they own it and you are their servant and you will take care of it when they want it done and how they want it done and who they want to do it. We said that happened too. Tenant protection, unfortunately, we screw the owner and landlord legislators like to pick names to get the people behind their agenda. Evan, is absolutely true. We have said on our channel a few times that the Housing Stability and Tenant Protection Act is already against landlords. To be a tenant, you must rent property from a landlord or a housing provider, whatever you want to call it, I don't care. So when you have tenant protection, in the law name itself, the act itself, says that the legislators drew up legislation and was passed into law with Governor Cuomo on June 14, 2019. Tenant protection says we're going to protect you, tenant, from the landlords. Against the bad ones, sure. But that legislation is terrible. I will tell you that one of the things that we have been addressing with that, the biggest thing that we want to see changed in the law, and I think I can speak for every landlord in New York State when I say this, is that when we have to know the names of everyone that lives on the property. If we don't know them, they stay. They get to stay. The ones you want out get thrown out. Their names have to be on the warrant. That goes right along with this new law, this new moratorium. You get to that point where you're getting that tenant out that you don't want there anymore, you can't stand. Well, now the sheriff comes to throw them out, and now they have other people living there. Those people get to stay. They get to stay. As I'm sure we have said right along, we want that aspect of the law removed, as well as the aspect that you can't check the name of a tenant if they have been evicted before. We should be able to check that name. You can't check the name for that. What other benefits that we have to do a background check that the government will eventually remove from us? And the only thing that we can base the tenancy on is the size of their shoe, or the or the color of their hair. No, we might get in trouble for discriminating on that. What will be left for us to determine whether or not we want the tenant living there? They smile at us or they frown? Who knows? Oh, Bill. Okay, Bill. I'm sorry, Bill. Now I know who you are. Yes. I saw that you called earlier. You left an email for us. But as you can see, we were getting ready for the show, so I did not respond to that. Let's see if there's any more. I know that we may have missed some here. I'm telling you that we're not applying ERAP. Hasn't shown up in court 2 times. Well, that is the judge accusing my husband of breaking the ERAP system, so she couldn't apply. Yeah, he broke it, all right. He broke it. He's in charge of all New York State. So he broke the ERAP program, so she could not apply. Oh my God. Some of these things you have to laugh at. And I've never, even after 30 years, this is our 31st year in business, I always say, I've heard it all, and this is a new one. ERAP is a federally funded program provided to the states. Why the law is not oversight by Congress to ensure constitutional rights are protected, such as other programs like Medicare? The ERAP program is not one that's a constitutional issue. It's more of who's going to get the money and who isn't. the moratorium has been looked at for that. Now, I will tell you, the ERAP program basically says that the money is supposed to go to the tenant, and the tenant is to take that money to pay the landlord. That's how it's really supposed to be. New York State has actually said, no, we need to send it to the landlord. So they did one thing right, but that's a good thing. So you're right. Why doesn't Congress have that? I would say they gave it to the states and hoping that the states would do it right. Well, that was their first mistake. Well, then again, what faith can we put in Congress to do things right nowadays anyway? And I'm not talking party, even though I want to. I'm not going to talk political party. But we'll see what's going on with this. Evans said it may take a federal petition to declare each part of this bill unconstitutional. We saw what happened when President Biden, through the CDC, extended the moratorium to October 3rd. That ended very fast and was shot down. We saw the ruling of the due process aspect of the New York State Eviction Moratorium that was shut down early part of August. But you see what they did. They reworded it in such a way that they applied it. When the Biden administration knew that it was not going to withstand judicial muster, they said, well, by the time it gets heard, it'll be October. Well, he was wrong. His administration was wrong. CDC was wrong. We have to ask ourselves, do we fight this new moratorium? And will it be heard fast enough that it will eradicate this bill and this law and get us into court faster without having all these impediments put upon us? Who knows when it will be heard that fast? That the government provide free housing. I'm responsible for my family and not strangers. You're right, Facebook user. That the government provide it. Well, they're making us do it. You can see that. We know that. Let me see if there's anything new. And if there isn't, feel free to ask more questions. I am here for as long as you want me to be. And I'll answer any questions that you may have. Like I said, Vitaliy was with me earlier. We have a lot of answers, but not all of the answers. So if we don't have an answer for you, please understand the reason why. This law is very, very extensive. It's a lot, and it's just some of it. Binder has even more aspects of what we have in the law. There's more there. So there's a lot. And that's just the small binder that I brought to my studio here at my office. The binder is all about yay thick, full of stuff. Let's see. We have new comments or questions. Is there a way to check the status of? I assume you're checking the status of the ERAP application is what you're asking. I assume that. The government, under the law that was just passed on September 1st, they're mandated under the Office of Court Administration to have the portal where the court can check on that. They are sending out emails, the state ERAP program, to landlords to see whether or not, or to let you know your tenant has applied. But they should be sending out emails to you to let you know the status. Let's see. So I'm hoping that you can. I don't know if you can actually check. I know that you get a registration number and the tenant gets one. And I don't know if you put in their registration number, you would be able to check to see whether or not. But they will tell you, or if you check on yours, it will be pending. And it should say when is it pending for, not just the word pending. Evan says, I'm also looking for having clients by a notice of claim. You know, I think that's a good idea, Evan, because it's been ruled unconstitutional from December through August. We could have had these tenants in court in January and had them out in February, because the ERAP program was not around then. So we could have had these tenants out and been collecting rent from as early as February ongoing until ERAP pops in. But those tenants would have already been gone, and you would have had tenants presently paying you the rent that was due. So to file a notice of claim, because they had an unconstitutional law that we had to abide by for months on end, I think that's a good idea, a notice of claim. Why not? The Bible said it's only $50. Why not? I may even do it myself. Well, frankly, I spend so much time helping you on social media and at my office that I don't pay too much attention to my needs when it comes to my tenants. But I do it because, as you well know, I care very much for all of you. So I don't know if I saw this earlier. Are those unpermitted units eligible for ERAP? Are we allowed to do holdover evictions on tenants in those types of units? I know that they are going through. I know that a dear friend of ours, Rosanna Murray, some of you have seen her. She is living through an incurable cancer right now. She's dealing with a tenant that is a nightmare for her. She has shared this all over media and at rallies and whatnot. And the issue is her house suffered during Hurricane Sandy, and there's issues there. We know that during the Hurricane Ida, many basement apartments in New York City were flooded, and some have died in those apartments. So when we look at the unpermitted units, I will be answering that. Like I said earlier, we have a lot of answers, but not all of them. I don't know if you can actually get money for an illegal apartment. Are we allowed to do holdover evictions on it? You basically should, because we have seen that the government is saying, code enforcement, building inspector, whatever you call it in your municipality, is saying these are illegal apartments where they should give a notice to vacate for the tenants to move. That may mean, though, that you will have to pay to put them somewhere because you put them in an apartment that was not legal. We understand why a lot of you do that for extra income. Can we blame you for that? No. But what happens now is that Pandora's box has been opened, and now you wonder what will happen to me. When they issue you a fine, when they charge you $1,000 for an illegal apartment, you have to get rid of them and get them out. You may be able to take them on a holdover, not so much now because they have to show transgressions against you, the tenants, or the property itself, and they have to be proven. But if it becomes necessary for that, to take them to court, I don't want any money, I just want them to move. You may want what they owe you, but frankly, you rented out an apartment that you may or may not have known you should not have. So with that comes consequences that you may not get any of the money that they owe you. Sorry, phone is free. So that's all right. The status of court dates. It depends on where you are, what your municipality is that you have the status of court dates. If you're talking about a case that you may have provided to an agency like mine or my team, we held all of them back so that we can analyze these laws and put forth the documents that are necessary to make sure that the eviction is not dismissed on procedural errors. But to check to see if your court is holding cases and having cases, I will call up your local court to say, are you hearing cases now? And let us know. Let us know, yes, this court is, this court's not. Some courts have not, and they have not for months, and they are not supposed to be doing that. Now, injunction actions also on hold. Thanks. Debbie, we did see that in this law that injectments are also on hold, that they will have to do a status conference or bringing them back to court. That was going through the Supreme Court. Injectment actions are more costly than a normal, for those of you that don't know, more costly than a normal eviction that you would have in a city or town court through that process, pro se. An injunction is through the Supreme Court. It's a way around these moratoriums, but the government is called out of that. And there is a section in this law that talks about injectments are also on hold. On hold as far as the declaration, having a status conference, not that you can't file them. You can file everything. Everybody can file everything, including ERAP applicants. You just have to see how far it can go and how far or how much you're willing to spend to challenge the hardship. Because you can take it to court yourself and challenge it. You don't need to hire attorneys, our firm, the Vitaliy. You don't have to hire any of us to do that. But you have to look at you have to ask yourself, will we be able to proceed as a layman or a lay person, lay woman, on going forward? Can we do this and win? Is it worth it? We had cases the other day where out of all the cases we had, one of them was pro se, and she made mistakes in court. And she knew, but she said, I did not want to pay for his office to represent us. So therefore, she was pro se, and it didn't go too well for her. Why can't a mom and one property landlord report non-paying tenants to the credit bureaus? I can't see why you cannot. One of the things that I know this has happened, I don't really like that idea, and I'll tell you why. Because it can be done to you. You can have a contractor that you hired who did a shoddy job and you don't want to pay him. They can put a lien on your home, and now that's hurt you. I like the idea of that, but when we do it, when our office does it, we do it when the tenant has already had a judgment issued against them, and we file a transcript of judgment with the county clerk's office. But I have heard of landlords doing that, filing on their credit report that they're not paying. That's something that I can check in more on and see why you can or cannot do that. But we'll check into that for you. Michelle, we have a tenant that did not move over $16,000 and will not apply for ERAP to cover past rent. We are sorry for massive small claims and trying to force their hand to apply. Do you see any legal issue with this strategy? Since they moved out, we have a tenant that did move owing, ERAP will not cover you. ERAP is only for those tenants who are in tenancy, who are in occupancy. So them, they can't apply because they're not going to get it. They have moved out. As far as these small claims, I know in the city of New York it's at $10,000. There's other ways that you can sue in other towns or other city courts like Albany, Schenectady, Saratoga, Mechanicsville, Buffalo, Rochester, all of them. The small claims is $5,000, but there's another way that you can file that to up to $10,000 in those municipalities. You can also take them to county court for $25,000. Supreme Court is much higher than that. You can file that. You just have to ask yourself. And one of the things I want you to know, Michelle, and everyone else, you have to ask yourself, the judgment, will I get any money from that? You may not, but you may be able to file that, or you will be able to file that when you win with the county clerk. And we have seen numerous instances where they off to the person that they owe money to, and years later they want to buy a house or a car, and it comes up and sneaks up on them, and now they have to pay that judgment. And we know an attorney who has since passed away, a great guy. That happened to him when he was first practicing law. He told the guy, listen, you're not paying me. He sued him. The guy acted him off and said, I'm not paying you. Years later, he went and said, I need to buy a house. What can we do here? Because he would not work with him in the past, his attorney, to settle it. The attorney said, yes, I can work with you. Pay everything that you owe me, including the interest, which was 9%. He actually owed more in poundage and interest than he owed in the original debt. So if it's worth it to you to file it, but we tell a lot of our landlords, don't throw good money after bad, Michelle, because is it worth it? You have to ask yourself that question. But why not? But as far as using that to try and collect ERAP money, that's not going to happen. You're not going to get any money that way. What about landlords that get a judgment in their favor and go to ERAP to collect their rent? No. Because as we had just said to Michelle, that question came in while we were answering Michelle's question, is that ERAP is only for tenants who are in occupancy right now, not those that left. And you've already got a judgment. There is a new program out there that the state has put out. We have not analyzed that yet because this law is most important to us, and Vitaliy as well, and my team. We're going to look at that law and see whether or not, I got to tell you, a judgment, I don't know. It may be in the time frame of COVID that you might be able to collect on it, or you already got a judgment against them. So I'm going to tell you, without seeing the law, I'm only talking on a speculation, so realize that I do not think that you will be able to. I do not think that you will. You already got a judgment. So if that were the case, a lot of my people that have millions of dollars collectively in judgments would be able to do that. The only thing that may be is that if you got the judgment during COVID, you might, and I don't know, we have to check into it, but if this judgment was prior to that, no, you're not getting anything. Not at all. They would never have the money to pay, Michelle. Shouldn't the government come for the period we were not able to collect? That's part of legislation and a law that they did pass right after this rotten law. They did have that. But because this law is so tough, and you know, I will tell you, part of it, they have it here, and I will read what they reference. It's so ridiculous that I took different highlighters to it. Part of the law is Section 1, Subdivision 3, of Section 3 of Subpart A of Part BB of Chapter 56 of the laws of 2021. Can you imagine that? Can you imagine that? That is so ridiculous to understand that it's crazy. So we dedicated our time when this law passed to just this law and nothing else. We still have more to do on that and to talk about commercial evictions and how you can proceed with that. But we will get into that and we're going to look at that and see how you might be able to get money from that. But there is money, I'm told, out there for that. We'll get information on that and we'll share that with you. Maybe not in the live show, maybe not. It might be on a video on our YouTube channel, the Landlord Advocates. Wish I knew who you were giving me a compliment, but whoever you are, thank you very much. You know that we're here for you, we're here with you. That's our line that we use when we close our YouTube channel videos. But I'm willing to stay here as long as you are, or until this chair gets uncomfortable on my skinny butt, and then I'll retire for the evening. But let me see if there's anything more. And keep coming with the questions. Keep coming with the comments. Feel free to vent. I didn't want to venting too much when Vitaliy was here because we were talking about that. But I have no problem with that now. I have no problem. Ask those questions. Simply, you're welcome, Michelle. You are welcome. And yes, it is very devastating with what we're going through. Okay, here's one. Espa, can you share with us what form that you displayed? What this is here, this is a notice that has to go on court papers, not 14-day, not reprimand, none of that. This now has to be given to your tenants when a summary proceeding is initiated on them. This basically says that if the landlord does not challenge the declaration of hardship that is attached in this packet that you get, and it is a packet. If they do not challenge it, you get to stay in the apartment until January 15th, 2022. We know that's a lot longer. It'll be March or April. And in areas of New York City with heavy population, it will be even longer than that because of the backlog. That's why when you want to get a court date for non-payment of rent, you have to ask yourself, do I have enough evidence to challenge it, and am I willing to pay for the processes to make that happen? If you really feel in your heart of hearts, and if you don't really know, you can ask professionals like us what the financial picture may be, what defenses you think that they may have to sign a declaration and have it withstand judicial scrutiny. You have to ask yourself that. Don't go in with, I'm going to do it anyway. And if you have the money to pay for that, you want to take a crapshoot and see if it works, go ahead. But you have to ask yourself that question. We can help you with that, with what you believe, the reasons for them not being able to do that. And with that also, we don't have it typed up yet, but the affidavit that must accompany all of that when you want the court date is that you believe, and you're challenging the declaration after they filed it with you in the court, that you believe under good faith that they are not suffering through any aspect of COVID, and therefore you feel you should be able to go and get the eviction. You're welcome. You're welcome. Jack, do we need to include that notice to tenant form you display for holdover cases? I would do it with all of them, Jack. I would do it with all, because I actually typed this up. The government, they told us in the law that this has to be in there, so we have to read it through all this. And I said, well, this has to go. It has to go on the top of all eviction notices, and that's what we did here. Your exemption, eviction in your hardship declaration form. I would do it anyway. It doesn't hurt. One of the things that the court said, you don't have to put any of this stuff in here at all. You don't have to do any of that after you're in the middle of August, because they're not giving it out, but we did it anyway, and we're glad that we did, because those cases would have been either dismissed or adjourned out, and that would have happened, and we don't want that. I see that we have, and I don't know who you are. I don't know, Nathia. I see that you are in the studio. That was a link that Vitaliy put out there. If you would, we have a private chat, and there is a few comments here. Oh, I see that. I apologize. Let me read that. Normally, I don't bring people on the show unless I know it's a little something. So let me read what you wrote here, and let me just give me a moment, everyone. Oh, yeah. Sometimes what should I bring? You know what we can do? If you're willing to share your story verbally on here, I'll bring you on and you can share that with us. And then we can talk about that because your issue is also something that will affect a lot of other people. Now, I will tell you, before I bring you on, do not mention her name at all. Don't say her name. And I'm not talking down to you when I say that because I'm not. But under the law, we're not supposed to know their names because they've been evicted. Even though you show me 10 times, that's a lot. My record in my 30 plus years has been 10 to 11. And this tenant that you mentioned has been evicted numerous times. So absolutely, we don't normally do this, but I've seen you trying to punch in a few times. And I will give you that forum to join us. And yes, this viewers, this is Natha. I hope I'm pronouncing that right. She has tried many, many times to get rid of her tenant. She can explain to us on that. She'll ask some questions, and then we will answer those questions for her. And one of the things that we've said many times in our office when we're on the phone helping someone and clients are in the waiting room, we speak loud enough for them to hear the answers that we're given because we might be answering questions that they didn't think to ask or that they weren't going to ask, and now we answer them before they had to ask. So that's been not on. Can you hear us?
Hello.
Hello there. Your camera's frozen, but I don't care if your camera's frozen as long as we can hear what you have to say. So go right ahead. Share your story with our viewers and in rerun the tenant that you have and the nightmare that she's causing and what's going on in your case. Go right ahead.
Okay, so basically, my husband is a pastor, and we came home from taking our family of 4 at the time. So I had 3 sons at the time, and we drove home and we saw a car covered in snow, and we saw that the church lights were on of our church. So we went in and we saw that this woman was living there. So being moved by compassion, we took her into our home. We do know her, but we didn't want her sleeping in the church. We didn't want her snowed in. She was there by herself with her son. She ended up basically being evicted several times, we know. So she's been evicted 10 plus times. She's a con artist, you know. So we decided that we were tired of her being in this situation and we wanted to help her. So we ended up, at this point, I say foolishly, paying her bills, her car insurance, her car payment. We paid for her child support. I had a 2-month-old at the time. And so we were doing all this while I was on maternity leave. When my husband and I got married, I had a house that we no longer lived in because we moved into his home. So we had 2 homes as single people, and we got married. The home was, we were like, okay, how about you just stay in my home until we get you on your feet? Again, all this is foolish now looking back, but
I'm glad that you realized that.
And she knew right.
I'm glad that you realized that.
Yeah.
You realize that, but don't ever do it again. And I yell at my clients, I tell them, I'm yelling at you with a hug, not with a fist. So I'm yelling at you with a hug. Don't ever do that. We tell our people when you start feeling sorry for your tenants, and forgive me for saying this because your husband's a pastor, we tell them, quit your job and become a priest. That's what we tell our clients when they feel sorry for their tenant. Because at the end of the day, and am I pronouncing it right, Natha? Am I pronouncing it right? Natha or Natha?
Yes. It's actually Maranatha, but yes.
It's what?
Maranatha.
Oh, Maranatha. Okay. Maranatha, I will tell you, the most important people in your life is your family, not the people that you want to help. At the end of the day, your children are more important. Your husband is more important. You know that now. I won't beat you up anymore. But now you have a tenant in a single-family home that you have court on September 29th. And is this the first time you've gone to court, or is this how many times have you gone to court with her?
Sorry if I hear, though, it seems like it's going in and out. I'm going to see if I can move it. But
how many times
I
have
have
you
a
gone to
lawyer
court
that.
with her? Okay.
I'm sorry?
No,
Is
how
that
many?
better?
I know you're saying you have a lawyer. How many times have you been to court with this woman?
I'm sorry, Carrie, my phone's being bad. I don't know if it's my iPhone or. I heard you better when my camera was off. Maybe I can turn that off.
If you want to, and we can communicate without that, that's okay. Because your information and what you have to say is
Okay.
more important than what you look like.
Okay.
So go ahead and
just
try
gonna try
that.
that and keep the mic on. Okay. No. Can you hear me?
It's breaking up on me.
Hold on.
Try that
Okay.
now.
Okay, perfect. Okay, can you hear?
You're breaking up, and I hate that you're breaking up on us. That's the problem when you use the iPhones or whatever, my friends, is that when you use that, this kind of stuff happens. I will tell you that our system here, and we had technical difficulties when we first started up today. We have cameras over here that we
think that
can't
may
show
have.
you. Go ahead.
I heard you say try that. My so it.
No, it did not.
No.
You know, let me see if I remove you and bring you back in. Let's see if that works. Try that. I'm going to remove you for a minute, and then I'll bring you right back. Okay? Don't go away. We have a system here where we have a gaming laptop. We're actually connected to the internet, not wirelessly. And we're up in the hills. Where I live, I'm up in the hills. I got lots of acreage around me, so we don't have the greatest internet, but we do it here because one, I pay for it, and two, we have it directly connected to the internet. We'll bring her back. We'll bring Matthew Lyman back because I want her to talk to us. But in the meantime, we'll see if there's any other questions. I think there was. Do I need to stay with the same attorney to file my eviction petition, not to happy with my representation? I hope it's nobody in my team that you feel that way. Please tell me it's not. That's the iffy one. I mean, you can fire your attorney. You can file a notice with the court that you ask the attorney to say, I don't want you representing me anymore. And then he can file paperwork with the court and say, I no longer represent this person. The attorney can do that. But before you do that, and feel free to follow up on this, please. Are you not happy because of the time frame that this has been taken? Or he or she is not communicating with you? I'm not trying to defend your attorney because I don't know who that person is. But we have had landlords who have, on our side, have also had some irritation too. And we have to let them know we have to move with a lot of pragmatism when we move forward with these to make sure that there's no issues that we're doing something wrong. Excuse me. That we're doing something wrong that will see your case dismissed. So feel free to elaborate. Let me know what it is that you are not happy with, and I can help you even more. So let me know. Continue. Answer. Send that to me. Yes, I'm live and in person. Live from Saturday night. No, it's actually Thursday night. Janie, love your channel. I want to move into my apartment. Can I use the following clause? Send it to me. And Janie, thank you. Thank you. We had some trepidation when I started the Landlord Advocates last year, right after COVID hit, is that I was worried that my speech impediment would become an issue for people. And they would think that I don't know what I'm talking about or that I am an idiot. Well, it's proven otherwise, that I'm not. This is a speech impediment that I was born with. I have overcome that. I served on a college board of trustees. I was a commencement speaker. I've served on many, many boards in our community. I have accolades from the city and the county where I do business from and live in. I have accolades from the New York State Education Department, the American Cancer Society. I can go on. as well as the New York State Bar Association for my activities. So it has not. So when you watch my channel and you comment and you like it and you share it, that's an affirmation for me that I'm doing the right thing for you and I enjoy doing it. Thank you. Let's see, I think JD followed it up with, an tenant resides in a building with 4 or fewer units. Good one right there, yes. I may decline to sell a lease or tenancy. Yes, absolutely. Did you watch my channel and ask that question even though you knew the answer? Is that it? But yeah, you're absolutely right. You can do that. But we have to look at what is the immediate family member. I know you came in late because we addressed that earlier, and that's perfectly okay. Perfectly okay. Is that the immediate family member should be a mother, father, son, daughter, grandparent. When you father it out to aunts and uncles and cousins 10 times removed, you're diluting the concept of the immediate family member. Now, what you can do in that case, the immediate family member must be living in the house or living in an apartment for 2 months. Put them in there for 2 months. You evict that tenant for that reason. After 2 months, that family member, if they are there just for that 2 months, for the purposes of getting rid of that tenant, go ahead. And then re-rent the apartment out to somebody who will pay the rent to you. Do that. And once you do that, you're fine. So absolutely, you can do this in a building with 4 or fewer units. You can do that. But make sure that the person actually lives there. A telephone bill or cell phone bill now, I'm aging myself. National Grid bill or Con Ed, whatever that is in your area, JD. Have that in their name that they're getting mail there. Not just that they're laying on a cot on the floor. You don't want that. You need to have something to wear. Say he's not aggressive enough. I don't know who you are, and I wish I knew. And I don't know who he is and who's not aggressive enough. But I honestly hope that you're not referencing me not being aggressive enough in what we do. And if you are, feel free. I want you to let me know. Tell me how you feel. And tell me what you think that I can do to improve so that New York State and the world know and the United States know how you actually feel. So if that's for me, let me know. Absolutely. We're all grown adults here. Let me know, Matt, I think you can do this or that. Absolutely. Do not fear telling me, because that's what we're all here for. Let me know. Absolutely. How to evict a nuisance tenant. Natalia, we had that earlier. There's a long part of that. This would be in the replay. There's a lot to it and how to evict. Again, no disrespect. Please don't misconstrue this the wrong way, but we don't want to go over that again because it's very long. But there are ways to do that. But what I will tell you this when it comes to a nuisance, you have to define what the nuisance is. If you want to follow it up and ask me or tell me what you believe the nuisance is, I will tell you whether I think it really is or not. We don't want to say, well, the tenant is parked with a motorcycle, or the other tenant should be able to park their car. No, that's not a nuisance. Let me know what you believe the nuisance is, and I'll tell you whether I think you can go forward with that, and then I'll give you some pointers on how to do that. Thank you for your clear response. Absolutely, JT. You're welcome. Jack says, is the 4 units or fewer unit clause included in the new eviction law? Yes, it is. That is in there. That it's under 4, you can evict, but it has to be an immediate family member residing in that dwelling. I want to hire you. Thank you. I will tell you, I do this video to help you. We have acquired a number of clients through our channel and social media, New York landlords, landlords only, and many others. My purpose here is to help you, to educate you, so you don't do something stupid, so you get something in trouble. As you know, our motto when we open up our Facebook videos and our live shows is that we are here to help landlords become better landlords. I will tell you, if you're anywhere in the Capital District area, Albany, Schenectady, Rensselaer, Saratoga, Warren, Washington, Fulton, Montgomery counties, and Schoharie County. If you're in those areas, you can hire us and we will be happy to help you. Even if you can't hire us, that's what we're here for, to help you so that you can become a better landlord and you don't screw yourself over later on. That's what we're here for. Yes, I saw that one earlier, and I'm glad that you asked it again. My tenant owes me $70,000. Isn't that a hardship? Or do I wait until I get to $100,000? The problem is that the hardship was filed by the tenant, not by us. Because we know a lot of us are suffering a major hardship, either by the tenants destroying the property, the tenants not paying any of their rent, or you combine that as well with tenants who are laughing in your face all the way having a. We know one who posted a video of them in Disney World, Universal, surprising her daughter that they were going on a trip to, her older daughter, adult daughter, had a video all over on that. Shows that landlord months and months worth of rent. She's been to those resort areas at least 6-7 times. So anyway, us suffering a hardship really doesn't matter to the government. We've seen that. So let me see if Nathia is not here. Natha, I pronounce, that's her abbreviation. That she's not able to join us. But her situation was, and I can go through here, was that she's got 4 sons, aged 4 and 20 months, 8, 4 and 20 months, and 4 months. I'm trying to evict a woman that has been evicted over 10 times. She knows the system. We have court on 9/29. What should I bring? I appreciate declining the job. Bring everything that you have. Everything. Even if it has to come in a rolling cart, bring everything. Years ago, I was a New York State licensed private investigator. And many times, not landlords, clients would come in with cases and they would ask questions. And then I would ask them, I didn't think you needed it. And I told them, that is not for you to decide. That's for me to decide. Give me everything that you have, and then let me decide what is important and what is not. That I was a New York State licensed private investigator for a number of years. So that's what we told them, and I'm going to say that to you as well. Provide everything. You forget one thing could end up hurting you. So bring every damn thing to court with you. Everything. Proof of the job that she declined the job. What proof are you talking about? A text message from somebody to say that she declined the job? So you have something from the job that says that she declined the job? If you haven't done that, do that. In your case on 9/29 that we had mentioned earlier, is that you would want to have your attorney, and I think you did say you had one, your attorney, if the tenant has already filed a declaration of hardship with you or your attorney or the court, a subpoena ducis tecum should be served upon your tenant asking for any information that will help your case to prove that she is not suffering at all. That's the number one thing that should be done. Right now, it's 20 days from now, get that served upon her. And if she does not come to court with what you're asking for to corroborate her claim, now if she has not filed a declaration, then you can't do the subpoena. They have to file a declaration first. Now she may wait until the last minute, 9/29, when you're strolling into court. Oh, here you go. Here's the declaration. Judge, here's the declaration. And at that time, your attorney should already have a subpoena ducis tecum prepared in case she does that. Bam, you hit her with the judicial subpoena. Your case will be adjourned out, but that's okay. It's going to happen anyway. And then you will be able to do your best to prove that they are not suffering. We never signed a lease. That's okay. A lot of you landlords believe that you have to have a lease. No, you don't. You can have a month-to-month agreement. You do not have to have a lease with your tenants. It can be as simple as a rent receipt establishes the tenancy. Trying to give her a place to stay so she can get on her feet. So we haven't seen the dime in 24 months come December. Yeah, 24 months. As we said before we got broken off, landlords, I know that some of you may want to care for your tenants and you want to help them as best that you can, and I understand that, but you're not in the business for that. The main purpose of being a landlord, yeah, you want to provide a nice home and help the housing market in the community, but your goal is to save as much money as you can and make as much money as you can. As much as our detractors will say that it's very wrong to have that mindset, well, that's what businesses do. You know, if putting a sticker on a paper bag at McDonald's or Burger King to make the bag look nicer, that sticker may cost them 2 cents, but when they have to do that to 20 billion bags, now they've handed out a ton of money. So you have to look at how much money you want to save and how much money you want to make. So in a case like that, you do not have don't allow your sympathies and if you're sorry for the tenant to get in the way. In this case, NAFTA has realized that mistake very painfully for 24 months come December, and it will be that long to get them out, possibly, of no money coming in whatsoever from someone who was sleeping in a church with her car, had no money, no nothing, and this good woman with her pastor husband, with her 4 kids, tried to help her. And this is the thanks that she got. She did file the declaration of hardship in this case, so it was filed. Since it was filed, I want the subpoena drawn up by your attorney this week and have it served upon her. Now, when you look at the declaration of hardship, there's 2 sides. One is financial, one is immunocompromised. How old is your tenant in this case? Is she over the age of 65? That's side B of the declaration. You can still challenge that. You can still do that. It's a little harder, but you can still do that. And that judicial subpoena should have those areas in there. She's in her 40s. No, that she can still say she's immunocompromised, and you will be able to. You will be able to look at her medical records for her to determine that she is or is not. HIPAA law does not play a role in that. Some people think that it does, that you can't disclose that. If a tenant puts forth the argument that they have a health issue, immunocompromised, I cannot move, I'm in fear of catching COVID, they are obligated to provide that information to you and to the court as to why they cannot. If they do not provide answers to the subpoena, the court basically has no choice but to rule in favor of the landlord and grant you the eviction, the warrants of eviction, the judgment, whatever the relief is that you're seeking in the petition, they should be granting that to you. Okay, we never want you to be landlords. We have plans to just sell it. Unfortunately, you are now, but let's see where it goes from there. Being a landlord is not always a bad thing. It's the tenants that can make it bad, or the government that we're in now is making it bad for us, but it's not necessarily a bad thing. Let's see, we've had some more comments coming in. Badass mom, dots. Okay, I'll just call you badass. Let's not swear, I'm not going to say that. Tenants are harassing another tenant on the property, turned off the electric, has late night parties, puts objects up against the tenant's car. Is this a nuisance? Answer this, turned off the electric. Who turned it off? Did you? Or is it a tenant? And when I say that, I'm not trying to be accusatory or putting the lights that are all around me on you. So please don't take it that way. If the tenant turned it up and they have no electricity, you can get code enforcement to come in. You may have to pay a fine that they don't have electricity, which you shouldn't. It's not your fault. But you may be able to get them out that way. Now, harassing the other tenant on the property, late night parties. We have all of these things now, everyone. We have all of these. Use them. Use them. Report it. The time is there. And the parties are outside. Videotape. You have cameras outside. Absolutely. Corroborate everything. If you think that you have enough, no, you don't. You need more. Bring in more. When I tell our clients to bring in what they have and bring in more, the more you have, you might be able to win your case just by them conceding and giving up rather than fighting. Puts objects up against the tenant's car. Objects. Could it be a little, and I'm not trying to be sarcastic here because you know I'm with you. You know that. Is it a floating little bunny rabbit? Or is it a bicycle up against the car? And can you have proof that they put it out there? And do you have cameras to show that? Because if you were to move forward with the nuisance, which you can, you have to ask yourself, do I have enough that will override the argument that they're not a nuisance so that I can get the tenant out with that? If this tenant who is being, the issues against them, the transgressions, that tenant will have to come to court and testify. A written document stating that is not good enough because the other side needs to be able to cross-examine. You can't cross-examine in document. You can't do it. You might say, well, Matt, isn't that what an invoice is or whatever? Yes. But one is accusing someone of doing something, and in that document, sworn affidavit, they cannot challenge it. So it has to be something that is substantial. Multiple police reports due to finding and breaking stuff, doing drugs, but how can I prove that? Natalia, just answer part of your question. Multiple police reports. You can FOIL them, Freedom of Information Law, from your local law department, corporation, council. Don't go to the police for that unless it's a small town with 500 people. You may have to go there directly. But you will go to your city, town, village, seat of government, and you should have a corporation council, a town attorney, whatever they may call it. And you want to file a FOIL to get the police reports on that house. You may not have to. I would call the police first, and they may say, since you own the home, we would give them to you, especially if you're owner-occupied, doing the finding and breaking stuff. I know this may sound obnoxious, or it might sound like I'm being mean. Please don't take it that way. When you say finding and breaking stuff, what? Are they breaking eggs on the pavement, or are they breaking glass and mirrors and doors and windows? You have to elaborate that and take it to the furthest extent. When I was a licensed private eye, that's what we did. I'm talking about breaking stuff. What were they breaking? What time were they breaking it? Where were they breaking it? Were they breaking it on somebody else's property, their car, their bicycle, their moped, whatever it might be? What were they doing and fighting? Were they fighting like, leave me alone, stop? Is that fighting? Or are they throwing hatchets and axes and bullets at each other? Are they hitting each other with frying pans? Are they doing it at 3 o'clock in the morning? If they are recorded. You also, this is a one record state. The other party does not have to know that you're recording them. So if you're on the telephone, record. If they're outside on the porch and they're yelling and screaming, record. You're allowed to do that. The more you have, the better your case is. Can I move, and I've seen this before, can I move in with a tenant since I'm getting a divorce and I have nowhere to go? I would like to say, yeah, go ahead, but no. Because the tenant in occupancy can bring other people in under the Housing Stability and Tenant Protection Act of 2019. They can. But you cannot willfully move yourself into that apartment. You can't move somebody else in that apartment because you rent into them. Only they have the right to move other people in. You do not. And even if you were, and this may be a tongue-in-cheek question, and it might be real, and I appreciate both ends. So I've had it happen. I've seen it happen. I've been asked that question. Would you really want to go in with those tenants when they might sabotage the bathroom, the toilet, the sink, whatever on you because you're living there now? I wouldn't do it. I wouldn't do it. Jack, are we looking to move family in? Are there special forms or special areas that we need to put in the termination notices or petitions of holdover? What I would do is what you just said right there, Jack, that pursuant to the law, I am allowed in the 4 unit or less. My immediate family member is going to take up residence in your dwelling, apartment A, apartment B, apartment C, D, 1, 2, 3, 4. I don't care, either one. And you really should have them noted so that we know it's a 4 unit or a second floor rear, second floor. You get my point. Having in the holdover. Now, because it's a termination notice and not for nuisance, you have to look at how long they lived there. So it's a 30, 60, 90 days. So you have to think about that. It's how long the lease was or how long they lived there for, whichever is greater. Less than a year, 30 days. More than a year, less than 2, 60. More than 2 years, 90. A lease a month to month, 30 days. But if that month to month covers over into a year, 60 days. Now, what you have to ask yourself, now pay attention, everyone. Clearly listen to what I'm telling you. Because it can be a tongue twister, but it's not. When you get the termination notice, let's say they moved in January, and come January 1, it is now 1 year, 60-day notice. Now, hear me. if you give them that 30-day notice, not you, the processor or your attorney, not you, that notice is served upon your tenant in November, remember I said November, to move out by the end of December 31st, 2021. Obviously, if they don't move now into January, the 30-day notice is still good. Why? Matt, why? It's going to be over a year when we're in court. Here's why. But before I tell you, subscribe to the Landlord Advocates on YouTube if you haven't already. Let us know that we're doing a good job. Give thumbs up to our video. Hit the notification bell for other videos. We are damn close to 1,000 subscribers. Let's get us over the top. Share this with everybody. When you do that, you're actually making me feel good and you're helping our channel grow even more. Now, in answer to that, here is why. You gave them a notice to move out the day before it became a year. They chose to disobey the notice that you gave them to say goodbye. You've done that, but if you serve it in December, no, because now it goes into January. So, and the same thing goes with a 60-day, turn it into a 90-day. If they've been there for 2 years, and now it will be 2 years come January 2023, you would give the notice to them 1 month before it becomes 2 years. Not you, and I keep saying you, I mean your processor or your attorney, whoever that may be. That you can do, yes. And we're just looking here for a few more. So, but I want to say thank you for all your information. You're welcome, Michelle. This is it. We are not alone, and you are not alone. None of you are alone as long as we're here. I'm 53. I just turned 53 on September 2nd. I'm going to be here as long, not tonight, it is, but I'm going to be here doing this as long as I possibly can for years to come to help us all throughout this. And yes, you're not alone when I'm here. I study these laws so that we can use them to help our clients in the real world and to help you on social media. So you're absolutely not alone, Michelle. No way. Let me go back up so I don't miss this one here. And then we'll go back to the one I just said. Tenant had spine surgery and filed a declaration stating that they couldn't move because of disability. It would be an undue hardship on the ways around this. One of the things I tell my people before I answer your question, badass, I will never tell you what you want to hear. Not because I want to be mean or anything. I'm going to tell you what you need to hear. And having a spine surgery, I think that may be a reason not to be able to move. Literally move the body and move the property that she owns out of the dwelling, whether it be a he or she. It's not saying. I think it will. I think that will. Unless the spine surgery was in 2010, but if it was anything recently, I think that would qualify for side B, because she can come in with doctor's notes, hospital reports, therapeutic that she may have at a rehabilitation hospital. I think that's not good for you. Do I want to say otherwise and throw their ass out right now? Yes, I do. But it's not going to help you if I lie. I think that you don't have a case here. I think that your tenant will be staying. Courts here in holdovers, they have been for months, or at least in my area they have. So chat with your court, Facebook user, and all of you on Facebook, when we do our new shows again, you need to authenticate through Facebook so that we can see who you are. You may not want to see, and you don't have to, but it just makes it more personable for all of us because we're all in this together, so I can see your name. But if you don't want to, because tenants can see this in rerun, I understand. But yes, in our municipalities in our area, we have been hearing cases for months, and we've had cases in court, and we were at the sheriff throwing people out. So yes. If the tenant is on the extra unemployment the entire pandemic, would that be an excuse for hardship that we can use in court? That, Jack, is where that subpoena justice teaching comes in. That they need to show payroll records. And they claim I wasn't working, but I was, and we can see, because we're asking for 2019 and 20. We want to be able to show the disparity, the difference in income, or is there any loss of income? That's why we're asking for that. It is shown that they were no longer working because of the pandemic. we know that there should have been collected unemployment. So that would be part of our argument that we would use. That's why with that subpoena, don't feel like you can't ask for everything. Ask for everything. Because there's so many components that they can claim child care expenses. So because there's no area then that they have to say that, out of Part A, 1, 2, 3, 4, 5, 6, 7, 8, they don't have to clearly say this is it, which they should. That they're saying this is the reason why I have child care, or I can't move, or I've lost significant income, or I lost my job. They should have to put that down, but they're not. So you have to figure all of it in. So with that subpoena, that's why normally subpoenas are like a half-page form, since it just half a sheet of paper. Our subpoena that we have is 3 pages long. That's what we're using here. And that was generated by my team member, Joseph Valano. He generated that. And we're refining it even more to make it even more stringent. And we're asking for all of that. The more that you ask for, that you know you can ask for this thing, Jack, and everybody else, you can. The more you ask for, the less they may provide, and the easier your case will be to win when you challenge this declaration of hardship. All right, tenant turned off the electricity. I would contact code enforcement and say they're living there with no power. And your code enforcement and building inspector's office should vacate them from the property. The problem is that it's not an eviction. So they can get the power turned back on and come right back in. You have no say in that. It's a temporary Band-Aid on what could be an artery being cut. But you can still call and then break the windows. For nuisance termination, only yes. For nuisance, only 30 days. But like we say, when the broken windows, not that I didn't see it here, but be prepared to show photos of the broken windows, be prepared to show all of that, and then when you had that, then you're okay. So yes, 30 days notice of nuisance causes some intentional and substantial damage, or a safety hazard, or a nuisance is only a 30-day. And it's a calendar month, by the way. Not 30 days from the date that it's served, or 30 days from the date on the notice, make it a calendar month. Some of them, it can be from the 30 days of service, but just do it, cover your butt, make it the whole calendar month. Wyoming didn't add any language on the termination notice about family moving in, and we filed a petition with the courts already. Will my case be thrown out? Maybe not. But that's what Vitaliy and I were mentioning earlier, and I'm leaning in that direction that they're not going to throw people out unless there's a reason for that. And in this case, since it's already been filed with the courts, if you're claiming that it's not a nuisance, it's not causing damage, so since it's already filed, I would go ahead with it. But what date is the case being heard? Do you know yet, Jack? If it's 3 months from now, you may want to think about starting a new one over just in case. But if it's in the next couple of weeks, let's see, and then it's running its course. So answer that question for me. Let me know. Daniel, good night from Chicago. Oh, I feel sorry for you, whoever you are in Chicago, for your mayor that you have over there. Oh, my God. They didn't do the same thing that they're doing in California with the governor. They need to do it in Chicago with your mayor, Lori Lightfoot. She's a mess. I know well, it's my show. I can get political if I want. But yeah, your mayor, she's something. So thank you. And you are welcome, and good night to you. Debbie, Matt, you're awesome. Oh, stop. Thank you. I'm definitely subscribed, notified, and always look forward to your new YouTube videos. We are so grateful to you. Thank you. Debbie, thank you. I'm giving you a hug through the computer for that. And I will tell you, this makes me very happy when I get comments like that and people subscribe. It really does. I care about these things. I have said before, I have cried over these laws at my office. When people send me stories about how hard it is, I do cry over them. I get mad. I get angry. That people think that this is perfectly okay to treat us that way. It bothers me. So, Debbie, thank you for those. I appreciate that. And I really do. Can I subpoena a tenant to testify that the other tenant using drugs on the premises and evict on illegal activity grounds? Was there an arrest? Was there a conviction? If not, how can one tenant say that they're using illegal drugs, using drugs? I'm playing devil's advocate here, but I'm also being honest and serious. We've had landlords that have used that argument with us before. My tenants using drugs. Have you seen them? Have you watched them? What drugs are they doing? Are they pills? How do you know that they're not prescribed for them? Are they smoking dope? That's legal. Are they liquid acid? No, I know that's a 1960s and 70s thing. And I'm asking you that because I'm on your side. I'm not against you. And you know that already. You already know that. But you have to ask yourself, can I subpoena a tenant to testify? That may be, you can always subpoena anybody you want to come and testify on anything you want. But remember, now you have two people who live in the same area. That's going to get even worse. That tenant may not want to do that. Because even though it may go in your favor, it could be another month or two before you get that tenant out. And now that relationship that's bad now, it may be this slapping each other, figuratively speaking. Now it's going to be this. Or it might be even worse. It might be this or even this. You don't know. You don't know. But yeah, you can. Illegal activity grounds, the best thing to do is to call the police and let them know what you suspect is going on. High traffic, people in and out. They were there for 5 minutes. They're leaving. And a lot of them don't even care. I was out the other day visiting a household, and a drug dealer took them right in front of my car, right in front of me. It's happened a few times. And they know me. I don't work for the court, but they know I work in the court system. And they didn't even care. They were doing it right in front of my face. So these people don't care. So whatever evidence you have, you have to say that. You can't say that they're doing drugs because it may be a prescription. So check on it. Be careful. I'm still waiting on a court date. Well, it was already been filed. Why hasn't a court date already been happening, Jack? I would call your attorney up and say, you filed, I should already have a court date. Way back last year, we had to mail in petitions, and then they would mail them back with dates. That box that was sent out was 20 pounds. Yeah, a 20-pound box that we sent to the court. Even though the court is so close to my office, I could walk to the court leisurely and be there in 5 minutes. We had to mail the box there. Look, why can't I just drop it off at the front door of the court with a mask? And they said no. Well, that was just another way to deter people from filing evictions. But I would find out and say, hey, when is my court date? I want to know when. Because that will determine what your next course of action should be. Why does that new notice need to be attached to the petition if tenant didn't even submit a hardship form? Doesn't make sense. My friend, I will explain to you that it does make sense. It may not make sense as you perceive it to be under the law, but when you ask that question, it absolutely does make sense that we have to. And I presume that you're asking that question because you don't think it makes sense when the government makes us do that. And it's ridiculous. I don't like it either. I would go on that premise. If you believe that it is something that doesn't make sense and I say you have to do it, you have to. You know, if you don't, your case is dismissed. So I'm going to go on that we're all on the same team here and they're all allies. And then you're asking that question because you believe we shouldn't have to. This notice has to be attached to the top of the petition papers. It has to be. If it is not, you run the risk of having your case dismissed. That is part of the 71-page law. And I'm not going to look through it because I've already done enough of this. I have spent nights at my office, locking myself in my suite and having my staff wait on everyone so that I can analyze this even more. I have 2 doors into my particular office. One I always have closed, and when the other door's closed, they know, don't bother Matt. He's busy. I got to focus on that. So we have to. If tenant didn't even submit a hardship form, now that they did not, but this is letting them know because in the documents you have to include the hardship, and this notice has to go on top of that as well. If you don't do that, this does have to be done with a 5-day, 14-day, 30, 60, 90. Only the summary proceeding landlord tenant papers. This has to be on the top. Literally on the top. Not in the middle, not at the bottom, on the top. I love this, so informative. Thank you. And I appreciate that because we have a lot of landlords that will call our office and come in and they want that one-on-one, and I wish that we could. but it takes away from the work that we're actually doing to help them do that. I had a client years ago who knew where I lived, and he showed up to my home, and I was working on cases. And his happened to be on the top that I was working on. He spent about a half an hour with me at my home. One, I thought that it was rude of him to come to my home. Not that I'm some, hierarchical kid or whatever. No, my home is my home. You meet me at my office, not at my home, unless you are invited. Well, he came. After about a half an hour, he said, well, are you going to do my stuff? I said, no, yours is going on the bottom of the pile. And that's where it went. It's still not done with all the rest, but it was basically my showing him. It got done, not all the rest at the same time. But it was my way of showing him that it's going on the bottom because you took all that time that I was allotting for you to work on your case. So in this case here, we do these shows and we do the YouTube channel in hopes that everyone will watch them. Yeah, it helps my channel, I'll admit it does. I'm not going to deny that, and you know it does. But by watching them, hopefully it answers a lot of the questions that you already have, so that my staff and I do not have to necessarily do that one-on-one on the phone, email. We've had people on our social media pages, NY Landlords, Landlords Only, are two predominant ones that we're on. We're on a lot more, but those are the ones that we are on the most, that we comment on. And we've had people that will send us a private message and ask a question. And we will tell them, please ask that question in the open forum, because you and maybe 2,000 other people are looking for the same answer. And it's not that we don't want them to provide it, but to do one-on-one like that is just not able to be done. But thank you, and you are welcome. It's stripping the electrical usage abuse and keeping our lights on even though the tenants go out considered a safety hazard. Are you? And I say this again, Jack. You're very interactive, and thank you. I ask this: are you paying the light bill? And even if you are, leaving the lights on, it's not really a safety hazard. I have we have a light on that we leave on all the time because it's a big hospital. We don't leave on every light. And we have a smart home, so a lot of stuff that we do is through our smart devices or through our voice. But yeah, now the electrical breakers, doing electrical usage, that could be an issue. And we have one, Rosanna, a doll, that could be an issue that she's faced with because of Hurricane Sandy. She has to get in there and fix the apartment, but that tenant won't leave so that she can go out and do the repair work that her electrician said needs to get done. Same thing here. If the usage could be that you don't have enough ampage in your home, that they are using technology or appliances that they are allowed to use under the law. You have to ask yourself that question. Is it a safety hazard? It depends on what they have plugged in, and if it gets tripped, like maybe a heater, we don't know. You have to show video or pictures inside the home of what they're doing. And cameras are so small, have your camera in your pocket and have the camera showing out while you're videotaping inside the apartment. You want to do an inspection and see what you can do. The more you have, the better you got. I only got an index number for my case, Melissa. No one knows when it will be. I'm in New York City. That's the problem, Jack. New York City is such a beast in and of itself. So I'm not saying it happened before, but like I said, I have a lot of answers, but not all. I don't know if that's how they're doing in New York City, but here, when we get an index number, we have either one of our staff members or one of our team members signs the petition on behalf of the landlord, or the court clerk will affix the stamp of the judge on it. And on that will be the date, the index number, and the timestamp from the court. So I don't know why they haven't afforded you a court date yet. And everything, New York City is. That's why I was saying with some of these evictions, it's going to be Merry Christmas 2022 for a lot of these people to get the hell out. Let's see here. What we will do, and I love all of you here, and I want to answer more of your questions, but I will wrap this up. We've been going for 3 hours and 33 minutes. Wrap it up probably around about maybe another 10, 15 minutes. We'll wrap it up. I don't want to, but my bedroom is calling me, so I'm going to be up early to help more of my people. That's what I call the landlords. I call you my people, not just landlords. We'll see if there's anything more. But again, the law is extensive, the one that Vitaliy and I did. And we'll do some more. We want to do more videos and we want to share more. But as you can tell, I also have I Do Legal that I run that with my team. But we are so busy. My God, we're so busy that I have to dedicate my time to my actual business as well. That provides me with the funds to pay for the backdrop and the cameras and the lights and the sound equipment and all of that. That's what keeps it going for me. Thanks, Matt. I hope you do more of these to help a small homeowners. You're awesome. Jack, I absolutely will. The live shows we'll do more of. I'm just sorry that I have all kinds of stuff. I have this thing called a stream deck that allows me to do all kinds of different things. We have cameras that we can interchange cameras and add all of that. But when I tried doing it today, I did it before and I can't remember how to do it again. I have a great tech friend, Tommy, who usually is on the show. He may be here as Facebook user, but Tommy always helps me with all this stuff, so he may help me to get it all integrated. But all of the stuff I do because I care, and obviously you already know that. Thank you, Jack. So if I send 30 days notice tomorrow, termination should state from 9/10. I would not do that. To some courts say no. I would look at it as October 31st, 2021. And notice served tomorrow. So if I said, you're not sending anything because you're not sending anything. I know that may be a play on words, but in my industry and I'm very analytical, I take everything that is said there and I will correct it. So you're not doing any of that. You can have it written up. You can do it yourself, but somebody else needs to serve it for you, and you have to look at how many times you're trying to serve it and how it was served. If you don't do it the right way, that whole case will be dismissed. You can do everything right after that, but if you do the one thing wrong that starts the case, it ends the case when it gets to court. You know what that happened. But the termination notice should be now until. One of the things that we mentioned to a lot of our people, when you do these notices to terminate for any reason whatsoever, except non-payment, of course, you have to ask yourself the persona of the tenant or tenants. How are they? Will they turn around and grow wings and a halo and become angels when you give them a notice to get out? If they do, give the notice now. Give it as soon as possible. But they will become the devil incarnate and become rotten and vicious and nasty and every other negative adjective I can think of. Don't give it now. Give it towards the end of the month. Around the 25th, 26th of September. You have to afford enough time for the process server to serve it. Yeah, you can do that. But that's what I would do because you know that they're going to be a rotten SOB when they're served. So you have to ask yourself, when is the best time to give that notice of termination? But you got to make sure, don't do it on the last day, because you got to make sure you get all of it done served properly, that the court will say it was done right. So you got to give yourself between this. We always tell our clients when they come to us, we look at the calendar and we tell them, you have until this day. They actually have a day or two after that, but we don't tell them that. They know now. But we tell them, this is the date that you have. After that, you may not have enough time for us to do what we got to do to help you. You're welcome. You are absolutely welcome. If there's any more questions, go right ahead. I know that we had Nathan, who was unable to join us because of her connection was bad. We'll do some more of these, I promise. Can you turn off the utilities? No, you are not going to turn off the utilities. No, no, no. That's a self-help eviction. It's a constructive eviction. It will get you in a lot of hot water, and fines here in New York State could be up to $10,000 for doing that. So no, you're not turning off the power. No way. I know it's against the law, but everyone tells me to turn it off in tapes and hopes that she leaves. I don't care what everybody else told you. We have done this on social media with on different landlord groups as well. And one of our strong advocates, David, who has watched Vitaliy and I numerous times, has corrected many people who post, oh, do this, do that, do this, do that. I'm sick and tired of that. I know that many of you who do that are doing it because you want to help. That you are doing it with pure heart intent to help. But you're not. You're not. If other people here not that had done this, because other people say it may make her leave, no. All it has to do is she make one phone call and code will be there and citing you for turning off the power. And she can sue you for it. So those of you that are giving those suggestions on social media and whatnot, stop. Stop. I'm not saying that to be, pointing fingers and being mean to you and yelling at you. Please don't take it that way. But take it that way as well. Take it either. I don't want to be that way with you, but I don't want you giving bad advice to someone. Because that advice could hurt them very badly in the long run. If you don't know any better, I'm okay with that. But if you don't know any better, and you're not too sure, don't give that advice out. Watch the Landlord Advocates on YouTube. Watch Succeed REI and our friend Vitaliy Volpov on YouTube. Watch us. Follow us on social media, and you'll learn a hell of a lot. I usually get up around 4:30, 5 o'clock in the morning, and I answer these questions. And that will be going on, not so much now, because I'm up a little later than I usually am, but I'll be answering more questions on New York landlords, landlords only, and other platforms that you may be a member of. I can't list them all because there's about 25, but we will help you on those as well. Thank you. These I can't show because it's a private chat, but thank you for your help, your passion, dedication, and compassion. I would hire you if I could. I have appointments in Socrates that's not in our jurisdiction. My team doesn't go out that far. My lawyers are the complete opposite of you. I have yet to tell her even what I got to tell you today. God bless you. And that's sad, because most of the landlords, or most of the attorneys rather, are pretty good. My team is very passionate. Sometimes, though, for one of my people, one of my guys, Joe, said, I'm not an educator, I'm a litigator. What happens when you hire my team, a lot of that comes to me. I digest it, I share it with our team members, and then we go to court, and then we argue the case. I don't argue them, they do it. I don't do that, that's their job. They will argue on your behalf. But I extrapolate all of the things that are not necessary, and I wash them away. I hear it and I care and I know, but it's not something that they need to deal with. So that's why I'm not saying that that's what your landlord or what your attorney is doing. But sometimes when we've had sometimes landlords that will call 5 and 6 times in one day to ask questions or to vent. And as much as we care and as much as we want to, we don't have time. Because the time that we dedicate to that is taken away from the time that we have to solve the problem that you've hired us to take care of. So find out. Don't talk to your attorney or lawyer in an accusatory manner. Ask them what's going on. Why have I not heard from you? What is going on with the case? Are you filing any of these papers? What can I do to help you help me? So do it that way. Don't get too into being too angry, because they may not help you at all. The tenant double or triples the electrical bill. That's the problem, Jeff, because at one time I went against my rule of not renting to a tenant who couldn't have National Grid in her name. She was great. She actually lived across the street from me, and I let her move in, and she was great at first, and then it just started going downhill. And it was bad. Not personal, she's a sweet lady, but I tell landlords I don't rent to tenants because I want to be friends with them. I rent to them to provide them with a place to live, and I can make a profit. Bottom line, that's why we do this. That's why we do it. So, or can I use this not as an argument and a holdover? The problem with that, Jack, is it seems like you had the power in your name. It may be because it can't be a shared metering situation. You don't want to divide the utilities up because it will be costly, and we know it will be. But because the electricity bill has gone high, that's not a nuisance. It is for your wallet. Oh, yeah. I got aggravated when my tenant wasn't paying me rent way back before COVID, that I was paying her National Grid bill and heat bill while she wasn't paying me the rent. Oh, I was pissed. Trust me, I was pissed, but I still had to deal with it. And in this case right here, the issue being is that's not a nuisance only to your wallet, but not to live in the apartment. It's not a nuisance. You can try it, but I can't guarantee that you'll succeed. Try anything, my friends. If you're willing to try it and spend the money and the time, go for it. But I will tell you if I think that you will be able to succeed or not. I'm just not sure. We have no more questions or no more comments coming in. So you always go out on top. You don't go out on the bottom. We've had a great show. We've had a lot of people here. I feel bad ending the show when we have people still in the audience and asking questions. But I'm going to do that. You'll be able to watch this and rerun. We'll do some other ones. Feel free to suggest on our YouTube channel or NY Landlords or Landlords Only other upcoming topics you want us to talk about. We've heard some here now. We are going to talk about commercial evictions. We're going to talk about the money that has been made available to landlords whose tenants do not cooperate. We'll talk about, like I said, the commercial evictions and anything else that you think that we have missed. Feel free to let me know that in on social media or any comments that you have here or here, and we will be happy to help you. Until then, landlords, please subscribe to my Landlord Advocates or our friend Vitaliy station, Succeed REI for real estate investments or investing. Subscribe to our channel, hit the like button to our videos, share our content. This will play in rerun on YouTube and on Facebook. I should be able to do that. So until then, landlords, remember what I say on all of my videos. We're here for you. We are here with you. Remember that. And until then, landlords, take care. Have a great night.